Okay, at this time I'll call to order the February 6, 2025 Subdivision and Development Appeal Board hearing. My name is Andre Gianandrea and I will chair the hearing. All questions and comments should be directed through the chair. Will the board members please introduce themselves, starting with to my right.
Councillor Tanya Faubert.
My name is Christoph Breyer.
Will the administrative staff please introduce yourselves?
Ben Stiver, SDAB clerk.
Sarah Jones, SDAB clerk. Annika Dross, development planner.
Mike Stasiak, community development engineer.
Oh, Janice Agrius, the SDAB lawyer.
And Brian Kinsey, municipal engineer.
Thank you, everyone. We're learning the new microphone system, so bear with us while we're did we miss anybody? Okay, thanks. At this time, I'd ask if there's any changes, additions, or deletions to the agenda. Seeing that there's none, can I have a motion to approve the agenda as presented? Carried. Agenda is approved. Today, the board will hear an appeal by the appellant of a decision by the Development Authority to approve development permit application PL 202-40362 for accessory use and accessory buildings, accessory Nordic spa amenity. This is an appeal against an approval and conditions of an approval by the Canmore Development Authority. This part of the hearing is an opportunity. I'll just run through our agenda here briefly. Appellant and application introduction and opportunity for objections. This part is the opportunity for the appellant and the applicant to introduce themselves and to voice any objections you may have with any of the board members present. We are aware that this is a procedural matter in regards to the board members present, and we need to discuss, so we'll address them after the introductions are finished. With that, will the appellant please approach the podium and introduce yourself?
Good morning. Samantha Stokes of Rose LLP. I'm here with Bonnie Anderson of Rose LLP as well, and we're here representing the appellant Stone Creek Resorts, Inc.
Will the applicant please approach and introduce himself as well?
Good morning, Bob Homersham, lawyer for the applicant respondent in this application. And with me, who will be presenting as well this morning, is Mr. Burrell Fasecki.
Thank you. Yes, please. Okay, thank you. Does the appellant have any objections to any of the board members? Okay, thank you. With no objections raised, we'll continue. Does anyone in the audience affected by the appeal object to any of the present board members hearing the appeal? At this time, I'll outline the hearing process. The hearing will proceed as follows. First, the development officer will make a presentation, followed by an opportunity for the board to ask questions for clarification. The applicant will then speak to their appeal, followed by an opportunity for the board to ask any clarifying questions. The applicant will then speak to their application, followed by an opportunity for the board members to ask any questions for clarification. At that time, we'll invite anyone in the audience speaking in favor of the appeal to approach the podium, followed by those speaking in opposition, and finally those speaking neither in favor nor in opposition. After all verbal submissions have been received, I will ask the clerk to read the names of those who have provided written submissions, identifying those in favor, those opposed, and those neither in favor nor opposed. After all presentations have been heard, we may call a short recess. After reconvening, there will be an opportunity for the board members to ask for questions for clarification. Any person who has presented will then be given an opportunity to ask questions for clarifications through the chair of other persons who have presented. An opportunity for closing will then follow, firstly from administration, then from the applicant, then from any other party who has presented, and finally from the appellant. I will then ask if those who presented feel they had a fair hearing. Lastly, I will conclude the hearing. The board will meet in closed session to review the evidence provided and provide a written decision within 15 days of this hearing. Anyone have any questions regarding the outline of the hearing process? Thank you. Does the appellant have any concerns with the process? Okay. Does the applicant have any concerns with the process as outlined?
No concerns. May I just ask a clarification question? Sorry, I'm talking about for recording purposes.
Certainly.
Just have a question of clarification. The agenda says that the applicant, ourselves, will speak after the planning authority goes. Is that, I thought you said something different in your remarks.
Just take a quick review of that. So your question is if the applicant goes after the...
After the development authority
Yeah.
presents.
Okay,
I see.
So, do you see this? The agenda says it's applicant, then appellant. It says it's appellant, and then applicant.
Oh, excellent point. The hearing outline and the agenda state two different things. Can I ask administration for a little clarity on procedurally on that?
Yeah, the applicant will speak after the development authority. That's correct, yeah.
Okay, thank you.
Oh. So it goes applicant, so it goes development authority, applicant, appellant. Okay.
For the record, it's Bonnie Anderson speaking on behalf of Stone Creek, the appellant. The actual notice of hearing, which has the typical notice procedures, has the appellant going after the development authority, which is typically common for appeals where the party making the appeal goes first. And then the party against the appeal, of course, goes after that. So our suggested route, and in fact it was in the procedure notice that we received from this office, that the SDAB, that the appellant go after the development authority, and then it's the applicant. I can pull out that notice that would have been sent to us. I think it was about 3 or 4 pages into the actual package that we received about the notice about the hearing. Thank you.
Yeah, thank you. If we just ask for a moment to, please approach.
Hi, Bob Homersham. I have no objection to that proposed amendment to the order.
Thank you. Okay. Do we need to call a motion to change that, or are we able to make that change? Just a quick, okay. All right. With both, looks like everyone's in agreement with going that way. So, okay. Thank you for clarifying that. Annika Drust, if we could ask you to please proceed with your presentation at this time.
All right.
I'll get the hang of it by the end of the day.
Good morning, Mr. Chair, members of the board, and anyone joining today. My name is Annika Drust. I'm a senior development planner, and I'm here to present to you an overview of the amended development permit application PL 2024-0362. which is an application to amend the previous DP approval for an accessory use with accessory buildings in the form of a Nordic spa amenity space. So the subject site is located at 1 Silvertip Trail, which is home to the Mountain House Hotel, and it's bound by Silvertip Trail to the north and Palliser Trail to the west, and is located within the Silvertip DC district. So as mentioned, this application came in as an amended DP application. And what that means from a processing perspective is that administration takes in the application just like it would any other application, and it receives a new file number. The file manager would then do an evaluation of the application and determine whether it will be processed as a brand new DP application or whether it is considered an amended DP application. So as an amended DP application, the review would focus on the proposed changes only, as opposed to a brand new DP application for an entirely new project where the focus would be on the entire proposed development. And the reason for that is that the initial DP application would have already been fully reviewed and assessed, and a full review would be redundant and inefficient at this time. So although a complete application package is required once they apply, the file manager focuses on the specific amendments only and makes a recommendation based on those amendments. Acknowledging the reduced processing time that comes with just a smaller review process on our side, there's a lower application fee and generally a quicker turnaround time due to the reduced review scope, and that is meant to support developers as they need to make some minor amendments as they complete their project. And the application would still go through the 10-day application notice posting period, as well as the 21-day appeal period, a notification of the decision within the Rocky Mountain Outlook, and a notice of decision on our website. And all those were completed as per standard procedure on this application. And the application did go back to CPC, who was the initial decision maker. So moving on to the specifics of this application. So the proposed amendments focused on the overall spa experience for guests, the number of buildings, overall use of the site, the fence height variance, as well as some of the other details remained the same as approved in spring 2024. So some of the changes to this DP included exterior material changes, and a lot of those were done to provide a more fire preventative material. There is an expansion of Building D's basement, which was done for fire egress purposes. Some of the pool sizes were changed and locations adjusted. Landscaping was added, and a staff-only service path was added as well. All those changes were in compliance with the land use bylaw and the EDCG requirements, and the changes do not increase the density of the site, do not alter the overall use of the site, and have no significant impact on the intensity of the use. So although administration recognizes that all those changes are significant from a business perspective for the guest experience, they were considered minor in nature as they don't have a significant impact in relation to our land use bylaw requirements. So the previous approval, or the previous application, was approved by CPC and later upheld by the SDAB in 2024, in May 2024, with the addition of conditions. And for this amended DP application, which was approved by CPC in November 2024, administration recommended that the conditions mostly mirrored those SDAB approved conditions. So there are two additional conditions, which are the cancellation of the spring DP, as well as the submissions of as-built drawings at a later stage of development. And those simply reflect standard practice to ensure that we don't have multiple DPs for a similar project floating around. And just as a note, that any developer could really come in at any point and cancel their DP application if they no longer wish to pursue their development. And additionally, we have a variation of a previous condition, which is new condition 19, and the condition was updated to show the municipal authority for requiring pathway alignment. And that brings us to the MGA. The MGA stipulates that an appeal of a DC district is limited as to whether the development authority, in this case CPC, followed council's direction. If it is determined that council's direction was not followed, Section 687 of the Act provides the SDB the ability to confirm, revoke, or vary the decision. So should the board find that CPC did not follow council direction, administration recommends that the SDAB approve the proposed application subject to the conditions presented in Schedule A. And that concludes my presentation.
Thank you. Any questions from the board members for Ms. Drost? No, I'm not seeing any questions. Thank you. Are you ready for your ready to present?
I just need to plug in my
Yep.
computer.
Go ahead. Just while we're waiting, just a quick housekeeping item. If anyone, please make sure you've given your name to the clerks for the record, that we have that. Thank you.
Ready when you are. Perfect. Okay, good morning, board members. As noted in the introduction, for the record, my name is Samantha Stokes. I'm here with my colleague Bonnie Anderson of the law firm Rose LLP. We're here today representing Stone Creek Resorts, Inc., who is a neighboring landowner, affected party, and the appellant in today's proceedings. I'd like to provide you with a bit of a roadmap as to how the appellant's submissions will go today, and I anticipate you have our written materials before you. So I'll provide an introduction to the appeal, provide some of the background facts, and then I will discuss the first ground of appeal, which does raise a jurisdictional question. I will also provide a response to my friend's position on summary judgment, which in my submission is as a result of the misapprehension of the prevailing law on summary judgment, applications to strike, in particulars in a statement of claim pleading versus an appeal pleading. Finally, Ms. Anderson will then discuss and address the merits on the planning issues raised. With respect to our first ground of appeal, you may wish to address the first ground of appeal preliminarily before we address the merits, and it may be that both parties address that issue first, but we're in your hands on the procedure, and you may wish to decide that once I'm done my submissions. So with that preliminary introduction, I'd like to address why we're here today, what we're asking for, as this has been a bit of a circuitous route now that we're back before the board. I'll address that route in a moment, but it is important to place the appeal in context and exactly what we want the board to do. As we've outlined in our submission, Stone Creek, neighboring landowner, owner of the Silvertip Resort, is not against this development in principle. What it is against, however, is a continued uncertainty with respect to the location and alignment of a pathway, including in respect of the preservation of both lanes of Silvertip Trail and associated landscaping required to screen the development. Base Camp may ask you for sympathy in this hearing. But as we've outlined in our submissions, we're here back before the board again because of a situation of base camp zone making. So we're asking today that you grant Stone Creek's appeal on one of the following bases. First is that jurisdictional question first, the amended development permit is an abuse of process in light of the ongoing proceedings before the Court of Appeal. Alternatively, the public notification and materials available about the amended development permit both mischaracterize and mislead the public about the application being minor and amendments when in fact the application is much more. And as proposed here, there's a proposal to amend a development permit, but cancellation of the original development permit upon which those amendments rely. And we state that that's an improper procedure. Alternatively, you could determine that you adjourn the hearing in whole or in part, pending proper notice of the actual scope of the application, receipt of materials relevant to the entire development and not just the amendments, receipt and finalization of the Town of Canmore pathway and related infrastructure design and funding proposal, which would ensure, for example, that there is the pathway and required screening trees, and confirmation that this can be done without the closure of a lane of Silvertip Trail. And then further written and oral submissions based upon what I just outlined. Alternatively, we can proceed today with the full merit hearing as well, and so then we would ask for a granting of the appeal such that the amended development permit is refused for reasons that Ms. Anderson will address in further detail. Administration has provided some of the background facts, and I will outline those for you as well today, particularly in respect of the prior SDAB hearing and the process before the Court of Appeal. But we start first with an examination of the property itself. And so it's located at the base of Silvertip Trail, and currently there's a 99-room hotel and associated parking lot on the western portion of the property. There's a number of registered interests against the property, which somewhat complicates matters, particularly with respect to this pathway, including utility right-of-way agreements. As admin noted, the property is zoned as direct control under DC bylaw 09-99. So when we look back to the original development permit and where we are today, that goes back to as early as 2022, when Base Camp approached the town about a proposed Nordic spa on the property. Notably, pre-application comments from the town confirm that the developer shall be responsible for the construction of active transportation facilities along the north frontage of the site, Silvertip Trail, to pathway infrastructure along Palliser Trail in accordance with the town's integrated transportation plan. That can be found at tab 8 of our materials. Fast forward to February 2023, Base Camp applied for accessory buildings amenity space associated with the existing hotel. That was accompanied with Metaphor design plans from February 2023 and McElhaney engineering plans from February 2023. In August of 2023, Base Camp applied for a development permit for a Nordic spa on the eastern portion of the property with the one variance for fence height, which you heard about this morning. As there is no standalone spa use under the DC bylaw, the application was based on an accessory use and accessory buildings. By February 2024, the development permit application went before Canmore Planning Commission, acting as development authority as required under the DC bylaw, and the application was approved with 16 conditions. And we'll refer to that, as we've done in our materials, as the original development permit. I will address these conditions in a bit more detail as I proceed through my submissions, but of particular note is condition 1A, and that required Base Camp to enter into a development agreement with the town for municipal improvements. Of particular concern to Stone Creek was that it later learned that the town intended to use this condition to close a lane of Silvertip Trail for the pathway and landscaping, which Base Camp is required to construct or fund, as well as an on-site water line. Now, when I said at the beginning of my submissions that a lot of the issues Base Camp finds itself in are of its own making, this is one of them. As we've outlined in our submissions, the development is essentially jammed up almost to the edge of where they could develop the property, which has, again, a knock-on effect on the available room for these public realm improvements. So, based on these concerns, Stone Creek appealed the original development permit to this board for several reasons, which continue to apply to this appeal. For example, the Development Authority did not follow council's directions. The town did not follow the road closure procedures under the Municipal Government Act, Section 22, to convert a lane on Silvertip Trail to pedestrian and bicycle use. Addressing the screening of the fencing along Silvertip Trail with natural landscaping, addressing vehicular access onto Silvertip Trail, and a lack of condition limiting the spa to hotel guests only, not day guests. The appeal was heard over 2 days in April and May 2024, and this board released its decision on May 24th. In doing so, the board added 5 new conditions, requiring Base Camp to enter into a development agreement, to pay for the pathway, enter into an access easement agreement for the pathway, to install natural screening along the fence, provide emergency access, and limit the use of spa to hotel guests only. So now, at the end of that process, there were 21 conditions in total. And Ms. Anderson may address this, so I want to introduce this for you, but the plans that the board decision was based on were metaphor design plans from August 30th, 2023, as amended in January 2024, and then the McElhaney engineering plans from February 2023, reissued for DP August 2023, and V2 on January 9th, 2024, so 2 sets of plans. Subsequent to the issuance of the board decision, on June 19th, Stone Creek filed an application for permission to appeal the decision to the Court of Appeal. And one of the questions raised specifically addresses 4 conditions. 1A, conditions 17, 18, and 19. And on the screen, so then you have them available to you, these are the 4 conditions, and I'll just run through them with you. I addressed condition 1A previously, and that is in respect of the entering into of a development agreement. Condition 17 addresses that the development agreement with the town shall include the requirement to construct or pay for the construction of a pathway as part of off-site requirements, with the alignment to be determined to the satisfaction of the town. Condition 18, the applicant shall provide an access easement to accommodate the location of the pathway as required. 19, the fence shall be screened by natural landscaping along Silvertip Trail in keeping with the context. While there were some discussions between the parties over the summer months, we did proceed with the leave application. We appeared before the Alberta Court of Appeal in September 2024 with the Honourable Justice Tom Wakeling releasing his decision on October 18th, 2024. In doing so, he provided leave to appeal on all questions of law or jurisdiction we raised. And those questions of law and jurisdiction are up on the screen for you here. And so I will run through these briefly for you with questions 1A and B. Both address the proper procedure for the closure of a lane of a road under Section 22 of the Municipal Government Act. Questions C and D more address in respect of the interpretation of the DC bylaw, whether the site is currently in compliance with the bylaw, and then to address Section 643 of the Municipal Government Act dealing with non-conforming uses or buildings. And then finally, of particular note to the matter before you today is E, and that is a question as to whether the board erred in law in approving conditions 1A, 17, 18, and 19 of the development permit. So in particular, two of those conditions, 1A and 17, are being, parts of them have been totally revised, and the development agreement under 1A is being proposed to be cancelled. Our notice of appeal was filed in October, and the appeal record will be provided in compliance with the deadlines of the rules of court. So moving from the original development permit and the appeal process, we'll move into where we're at now with the amended development permit application. And as confirmed by administration this morning, it was treated as an amendment application. So somewhat by happenstance, Stone Creek became aware of changes to the development permit in December 2024 after discovering the public notice advertising of CPC's decision to amend the development permit. So through that process, Stone Creek learned of the development agreement executed between Base Camp and the town, a number of new plans, which we address and outline at paragraph 28 of our submissions. And notably, some of those plans are brand new, some are renumbered plans, and others entirely replace prior plans. Almost all of the plans before the board are marked with quite a few changes. When CPC agenda materials for the meeting on November 28th, 2024 described the changes, they were generally described as regarding matters such as exterior materials, pool size, location, and the fence. Those same description was provided to you in administration's presentation. However, what was critically important and missing from this description is that there is the entire removal of the proposed pathway alignment and screening trees from the plan. The CPC public notice of the decision describes the application as, and I'll quote, variances proposed, amendment to PL 2023-0037 approval, changes to pool location, sizing, exterior finishing materials, and landscaping. Moving on from the agenda package, similar description. It's described as site plan and building design amendments to PL 2023-0037. It also states and I'll quote, the amendment to the site plan and building design is minor in nature, as it does not alter nor increase the density, use, or intensity of use. Administration recommends approval of the application, which would replace the original development permit, PL 2023-0037. After a very short meeting, CPC, though provided the option to look at both the entire development or only amendments, decided to look at only the amendments and approved them without further discussion. Concerningly, there was a question raised about the Court of Appeal process, but the panel member was advised that it was not a planning matter to be considered. And notably, there was no mention of the Court of Appeal granting leave on a development permit that was proposed to be cancelled through the amended development permit, or that leave was provided on conditions that were proposed to be amended by the amended development permit. And again, we see from the amended development permit is we have a cancellation of the original development permit. The conditions from the original development permit are being moved over to the new development permit. There's also additional conditions. And again, as I said, one of those conditions cancels that original development permit and the related development agreement. And the first condition that is of salient to you today that was revised relates to prior condition number 17, which is under review by the Court of Appeal. This condition is regarding the path. It's also of concern that the plans removed reference to the path when the issue of the potential uncertainty around the alignment of the path, the closure of a lane of Silvertip Trail, is all before the Court of Appeal. So when we look at condition 17, which is now, okay, there we go. When we look at revised condition 17, which is now condition 19, this, as you'll recall, that prior condition was to address that the town and Base Camp were to enter into a development agreement with respect to the path. And now we have here that the development agreement with the town shall require the developer to pay for the construction of a pathway to connect its development to the pathway system that serves or is proposed to serve an adjacent development under the town's authority under section 650 of the MGA. And then it states here, this requirement may be subject to the alignment of the pathway being approved by the town by its delegated authority under section 13 sub 1 sub A of the Traffic Safety Act. I won't go into the specific details here, but that's the one option, or as necessary, but as delegated authority under section 22 of the MGA to close part of a road by bylaw, or both A and B. And again, I remind the board that this specific issue, the closure of a pathway, or the closure of a lane of a road for a pathway, is a specific issue which we have leave to the Court of Appeal to address. The other main revision of concern is to add 2 new conditions, and so in particular condition 18, but the 2 conditions are the developer shall submit a comprehensive set of record drawings within 90 days of CCC acceptance, but then condition 18, prior to the issuance of development permit PL 2024-0362, file PL 2023-0037 will be canceled and the associated development agreement for that original development permit discharged. So the reason why this condition is a concern for this appeal is that notwithstanding that the original development permit is being canceled and the associated development agreement discharged, the development authority only looked at the amendments to the development permit rather than examining the entirety of the development. I'll now get into our appeal issues and our first ground of appeal now that I've addressed the background. We've outlined that starting at paragraph 42 of our submissions, and as an introduction for our submissions, our appeal must be placed into the overall context of a municipality's planning function. That's of course found in section 617 of the Municipal Government Act. The Court of Appeal has commented on section 617 of the MGA and its Love and Flagstaff decision, and provides that the values in section 617 are critical components in planning law and practice in Alberta, and flowing of these is the need for certainty and predictability in planning law. Before I address the first ground of appeal, I will briefly address my friend's position that Base Camp is entitled to summary judgment of the appeal. With the greatest respect, in my submission, that position holds absolutely no water. In its submission, Base Camp suggests that Stone Creek's Notice of Appeal sets out 6 purported grounds of appeal, each of which should be summarily dismissed for either being without merit or failing to provide sufficient detail to establish an actionable cause of action. Based on our extensive submissions, there's no merit to the proposed summary judgment motion. There's obviously tribal issues for you to decide today. In any event, and I will refer back to the rules of court because that is where summary judgment procedures come from, and those were the cases that my friend relied upon. So those are generally used in court processes, and under our rules of court, there's the overarching Rule 1.2, which encourages parties to address litigation in a fair and just manner, fastest, and for the least expense. Basically, what summary judgment will allow you to do is to have an off-ramp to address matters before you actually have to get all the way to trial or even through some of the pretrial procedures. But generally, once you've booked your trial, you're done with applications. No more applications can be brought. So again, this isn't, I understand we're in the SDAB processes, this is not apples to apples, but if we can provide some similarities between the procedures, we're at the hearing. This type of motion would make no sense when we're already before the hearing proper. So again, we just submit that the idea for summary judgment, not only does it have no merit in the actual application, it's just not the appropriate procedure today. But I will note that Base Camp has not addressed Stone Creek's arguments in detail besides this motion. And again, coming back to the theme that Base Camp is in its current position because of its own choices, they had every right to ask for staggered submissions a week apart. They did not. We had concurrently filed submissions. Now, I do wish to address the reference that you have to provide in a notice of appeal sufficient detail to establish an actionable cause of action. This conflates what is before you. Before you is, of course, an appeal. Causes of action are pled and raised in a statement of claim. We have grounds of appeal, which we have outlined in sufficient detail. I'll, of course, remind the board that, yes, there's counsel here today, but often before you, there is no counsel, and notices of appeal may be scant with detail, which, again, I do not agree our notice of appeal is scant with detail. But beyond that, there is no cause of action that Stone Creek has against Base Camp. This is an appeal, not a statement of claim. So, our first ground of appeal, this wasn't a proper amendment application. This is actually what needed to be done as a new development permit application. We submit that this was done in a somewhat creative attempt to shield its development permit. And in doing so, it looked to amend the original development permit through the amended development permit, whereby everything is, there's certain amendments that were before CPC, but everything gets moved over and the original development permit is canceled. This, in our submission, is a colorful attempt to get a new, fresh development permit which negates the Court of Appeal process without the entire development permit being open for review. We submit that this is improper for a number of reasons, and in my submission, Base Camp was required to do what most parties will do in this situation. You prepare a new development permit application with a full set of clean plans, and you go through proper advertising, and it is done as a new development permit. And the first reason why we state Base Camp was required to do this is on the basis that this process it has engaged in is an abusive process. So the original development permit is currently before the Court of Appeal. Issues such as the alignment of the pathway, potential closure of the lane of Silvertip Trail, and whether the board erred in law in approving certain conditions. And now, with respect to those issues on appeal, the amended development permit fully removes the pathway and landscaping, including screening trees from the plans. purports to amend yet entirely cancel the original development permit, purports to discharge the development agreement under condition 1A, and then redrafts condition 17, which addresses Base Camp's requirement to enter into a development agreement to construct or pay for that pathway system. Yet, it continues to leave the design of the alignment, funding, and associated potential lane closure or preservation of those lanes completely uncertain. And in our submission, it's the actions of Base Camp as well as CPC that attract the doctrine of abusive process, which, to outline for the board, prevents the misuse of judicial procedures in a way that would be manifestly unfair to a party to the litigation before it, or would in some other way bring the administration of justice into disrepute. And I have seen comments from the Court of Appeal where if these types of processes are upheld, then this board would be sanctioning an abusive process. I note that not only are Base Camp and the town a party to that appeal, but as is the board as required by the Municipal Government Act. And again, as I outlined previously, there is, and even as administration noted, a developer can come in, cancel their development permit that might be before the Court of Appeal and apply for a new development permit. We're not saying that that's an improper procedure. That's quite commonly done. But there's risk, and you take the risk. Do you take the risk with the Court of Appeal, or do you take the risk with the full development permit review? And that's a trade-off in avoiding appellate review. But again, this isn't what Base Camp's done. Essentially, it's trying to have its cake and eat it too. It's attempting to amend its development permit with respect to the issues before the Court of Appeal, cancel the underlying development permit, but bring over those same conditions or amend the conditions which are before the Court of Appeal, which would probably require another leave application. First, I have raised the issue as to whether portions of the development permit which are under review by the Court of Appeal can be revised and amended under that same development permit. We submit that cannot be done under this doctrine of abusive process. Overall, Base Camp is otherwise trying to circumvent the Court of Appeal process, which I anticipate Base Camp would argue in those proceedings is dead, with the cancellation of the original development permit, and otherwise try and shield its development permit from full review. On this basis, the amended development permit must be set aside, and we do question whether there's jurisdiction of the board to address revisions to a development permit under appeal. And I note the, of course, wrinkle in this case is that Base Camp has started construction under the original development permit. So in response to my friend's position in their argument, this isn't an issue with respect to the Court of Appeal process staying the development permit. As I just outlined, they have started construction. We're quite familiar with that law, and that's not our argument. Again, it's all about abusive process. The second preliminary issue is regarding the extent of amendments, which we state necessitated a new standalone development permit application. If you accept this argument, then of course you have no jurisdiction. So to provide you with a bit of context, while the Development Authority described the amendments as minor, and therefore there was no overall review of the development permit, there's a 15-page letter to the town describing the amendments during that application. It's not a minor amendment application. Public notification, as I outlined in my introduction, misdescribes the amendments as minor, but not true. As I've outlined the theme through these submissions, of particular importance is that removal of the pathway from the plans without a replacement design, raising questions as to whether the directions of council in the DC bylaw regarding pedestrian-oriented streetscapes are met. There's also the issue regarding the removal of the tree screening, which raises, again, uncertainty with vis-a-vis the directions of council and whether there's an ability to accommodate all required improvements, municipal improvements. Other amendments do include the increase in intensity of use by moving the mechanical area on site, thereby allowing more room for guest activities. Now, we again acknowledge that the Development Authority has discretion in processing development permit applications, but it must act fairly and transparently. Because of those significant amendments, we submit that a new development permit application is required for the assessment of the entire development. Finally, and I think what is most glaringly obvious with this is that there is an inconsistent characterization of the amended development permit. While there's discussion about it being an amendment, the recommendation was approval to replace the original development permit with that original DP being cancelled. I submit that this is an admission that this is in fact a new application, which necessitated proper advertising. Again, without the proper advertising, the board has no jurisdiction to hear the appeal, to hear the merits of the appeal. Finally, to close on this first round of appeal, we submit that an amended development permit cannot rely upon a prior development permit that is cancelled. If you amend something which is cancelled, all you have left are the amendments. That original permit is gone. The amendments in this application cannot stand on their own, and the entire amended development permit must be sent back to be processed as a new, fresh application. As noted in the beginning of my submissions, we're in your hands as to how you would like to proceed, whether to address these preliminary jurisdictional questions, or if you would like us to proceed on the merits, in which Ms. Anderson is available to do so now.
Any questions from the board?
Thank you for your submissions. Just a question, is there not some process that when you apply for leave to appeal, you could get an injunction or some sort of legal process so that the applicant can't change anything ever again while you're under that process? Is that not available?
Through the chair, there is a process that would be basically what you would be doing is applying to stay the decision of the SDAB. That would, it's a tripartite test to apply for the stay, which is similar to the injunction test, which you have referred to. That would be, for example, to actually stop them from proceeding with development under that development permit. Those applications, again, it's a weighing of issues, particularly whether there's irreparable harm with them proceeding with the development. This is different. We're not arguing that that the Court of Appeal is staying the decision. What we're stating is that when the Court of Appeal has provided a party with leave to appeal on specific issues, and then those specific issues are amended, and which will then, and the original development permit canceled with the new amended development permit replacing it, basically circumventing the whole Court of Appeal process. That's where it's bringing the administration of justice into disrepute, and that's where we say it's an abusive process. So I don't want to conflate the issue of a stay versus abusive process. They would be different things.
Interesting. My impression is that I heard you saying that they no longer have a right to, as a property owner, to make applications to the Development Authority to change what's already been approved because you have leave to go to Court of Appeal. Is that right?
So in this yes, because it would be the abusive process. In this typical procedure, when this happens, and Ms. Anderson has significant experience with this issue, when you have a matter before the court, when you have your matter before the Court of Appeal and you want to potentially address the issues before the Court of Appeal, we don't agree that this amended development permit addresses the issues before the Court of Appeal, which is, again, that's the concern. But if you think that you're able to address the amended development permit or address the issues before the Court of Appeal, the proper way would be to cancel, as admin said. You can come cancel your development permit. That does get rid of the Court of Appeal process. You apply for your new development permit, but again, That's where you have to take a bit of that risk that your whole development is reviewed. That process is proper, but amending and addressing something in the same development permit that Justice Wakeling granted leave to appeal on, that's where it's an abuse of process. And of course, the abuse of process is quite a flexible doctrine. It's under the overall overarching doctrine of res judicata, which is you can't relitigate issues. And so it's a very flexible doctrine, which we state and submit would apply in this case.
Okay. And then, are you, in part of your submissions, it felt like the suggestion was that the determination of whether or not this was an amendment or a new application was done by the applicant, but when I heard administration's presentation, they said the process is that they determine whether or not the changes being requested would go this way or that way, a new application or an amendment. Am I confused about what you're suggesting, or am I confused about what administration presented?
No, I think there may have been a misstatement in what I was referring to, but it's the whole process in that has it was processed as an amendment in light of the Court of Appeal. That's the issue. The thing is as well that my understanding is that the full set of plans were not provided. It was just the amendments. So the application as it was provided, and Ms. Anderson can speak to this in more detail, wouldn't be able to stand on its own because there wasn't a full set of clean plans provided. So that's where we would submit that it still was both the applicant and admin understood that this was being done as an amendment.
Okay, thank you.
Any further questions from the board? You raised my question, so thank you. Thank you.
Okay, thank you.
Believe we have a request for a recess. Is that correct?
Just so, yeah, but.
Okay.
Yeah. I'm not gonna TM on you.
Well, the board will stand in recess for approximately 10 minutes. believe that's everyone. Our remote, our Zoom members back as well. Appellant ready to proceed? Okay, we will re-adjourn.
Thank you, Mr. Chairman. My name is Bonnie Anderson, and I will continue with our presentation. A couple items to begin with. Number one is we have put together a slide presentation. We gave copies to the board and to the applicant for their records. And I believe you have that. I will go through the rest of the slide presentation, and where we refer to records, I will refer to the page number. Most of the slide presentation visuals are not new. Again, I'll refer to the record. However, we do have a couple items that might be considered new. They're primarily annotated items, but when you see them in the visuals, they will look quite a bit different. So I would ask, and Mr. Homersham for the applicant may have comment on this later, but I don't believe much of this is new, but I will, at least the annotated part is. So I would ask that the following records also be admitted. It is a one-page annotated diagram with respect to the cross section on the north elevation. That's the one-pager. It looks like that. These. Sorry, go
Apologies to
ahead.
interrupt. Has the applicant been provided with this?
Yes, all of these materials the applicant has been provided. Yes.
Thank you.
So this is one page. The actual background documents or visuals are all within the record. These are not new visuals per se, but the annotations are. So when we get to the slide, this I think would be considered enough annotations that it might be considered new. And it's one page, and we don't think that there's a lot here for the applicant to go through. So at the end of the day, we would ask that this be submitted. The second item is again, annotated photograph, and it's a two-pager. It's titled Figure 7, Aerial View. Those photos are actually very similar to the photos in the record at pages 333 and 335. And the only real difference is that these are now annotated with where things are at. So we would ask that be entered, and we would suggest that this is not a large new entry that the applicant would need to go through and review with and take a lot of time. So we're asking that be entered. And the third item is, again, annotated photographs. It consists of 1, 2, 3 pages. And again, it's just to give the board a sense of prior and current photographs with annotations. And again, our submission is that these are not voluminous things that the applicant would need to go through, but they are used in parts of our slide presentations, so we thought we would provide them in larger form, and the rest of the materials in the slide presentation are already part of the record. Mr. Chairman, is it fine for me to proceed?
Yes, please.
Perfect. So I just want to touch upon a couple things that were before co-counsel Ms. Stokes before me. It is our position that there is some discretion on behalf of the Development Authority as to whether to process something by way of amendment or a new application. Our submission is that the amendments here are so substantive and so many of them that it would have been best to process this as a clean application in the sense that instead of getting revised drawings, we would be getting a clean set of drawings. So we don't have a whole bunch of clouds around everything where things were changed, architectural clouds, I call them. And that because there's so many amendments, it's very difficult to tell what exactly is proposed now. And that should have been part of the process. Again, clean plans processed as a new application. When Ms. Stokes referred to a new application and referred to my experience, when we've had this happen before and there is a leave application, generally what we try and do is to correct for the items that came up in the original SDAB hearing. What we would typically do is hand in a new application, and we wouldn't just be asking for a review of amendments. We would be saying, here's our application in full, and here are some of the items that we've been able to rectify. So the whole application would be new, and the whole set of plans going to the board would be clean plans. They wouldn't be amended plans. They would be a clean set of plans without a whole bunch of annotations as to what's changed, etc. So at the end of the day, it is indeed the case. You can cancel your prior permit through the Court of Appeal process because you've come in with a brand new permit. In this case, they're trying to do both. They're trying to keep part of the old permit and all those conditions, when in fact the entire permit, any conditions, anything is available to change at the process the second go round. So again, to clarify, the new application is for the review of the entirety of the development with clean plans, and that would typically be how we would proceed if I were advising a developer. Now, our case is quite unique because we do have questions about the development in the first instance, that's before the Court of Appeal, that are relevant questions for the conditions that we're now trying to import into this process. So again, there's a clean way to do this, and we've got a very complicated way of doing this and attempting to circumvent. It's also complicated because we've already got a leave application decision. Often what happens is a leave application will be submitted, but we don't actually have a decision on the leave questions. And also, we don't have construction already proceeding. When, through the chair, one of the panel members asked about, wasn't an injunction or a stay available? When I act for developers, and I typically do, is a stay is certainly available, but you proceed knowing full well the risk is yours. If you proceed on a development permit approval, that is in the court process. And in our case, it's gone far in the court process. We've got a leave application decision questioning some of the conditions that we're looking at now. So that's kind of the difference in, or the complication, if you will, in how this process is all worked out. So we're saying that it wasn't our position to stop the construction. It's actually Basecamp's risk to even start it while it's been going through the Court of Appeal process. So with respect to ground number 2, there's a couple preliminary matters, and I'm just going to go through them fairly quickly because we have talked about them a bit already. But our suggestion is that if we are proceeding today and not stopping procedures on the basis of the preliminary matters raised by co-counsel Ms. Stokes, that we would ask for a re-advertisement of the actual scope of the DP. We'd ask for a clean set of plans and full record of the entire development. What we've got primarily from the record that went to CPC is just the parts of the amendments. Next slide, please. There we go. Okay, so with respect to the amendments, and Ms. Stokes touched upon this already, it's our position that the amendments are misdescribed, and they also look to replace the original development permit with this application. So the amendments are, as noted, they suggest they don't increase the density, use, or intensity of the site, and then they go on to list a number of amendments. However, there are some amendments, larger amendments, that are clearly missed in the description and clearly missed in some of the materials. Next slide, please. With respect to the amendments, I would suggest that the amendments are large and significant. At page 92 of the record, referred to in the upper excerpt, is a metaphor letter. Again, starts at page 92 of the record. That's a 15-page letter from Metaphor describing all the changes. On that basis alone, we would suggest there are substantive amendments that are being made, not minor. And we, at the bottom visual of this slide, we also add a page from record number 3, page number 3, and it again shows the extensive number of amendments. I refer to them as clouds. They're often blue or red on architectural drawings. There are very few pages in the package where there isn't a cloud around something. So what that means is every page of development plans we received has amendments in it. And we're suggesting that the extent of amendments made, the Development Authority should have requested this be processed as a new application, and we're suggesting that would have been the appropriate route to go. With respect to the slide, you'll see there's plan amendments and a number of clouds around the amendments. We'll go through a couple other pages which demonstrate just the extent of amendments. Next slide. The building amendments. The building amendments are extensive as well. And although you can't see on the slide, you will see in the presentation materials that this is from record pages 12 and 14. And again, just a sample of the number of amendments that were requested with this application. Next slide, please. One of the other amendments with the application, not just with the plans and with the buildings, but the area of development has actually changed over time. As the slide shows, this is an earlier slide, record page number 1143, and this shows the original application in its form, I believe, in 2023 and part of 2024's SDAB hearing. You will see that in the upper left-hand corner, there's a bit of a triangle up there, and then you'll see 2 forks coming out on the left side. I will refer you to the next slide. So that this is record number 1143. The next slide shows an amendment as to the phasing. So not only are we suggesting there's changes to the plans, changes to the buildings, we're also suggesting there's a change to the scope of the development area. In some plans in this visual, and I've highlighted it in yellow, in some plans it's getting more consistent in the new set of plans that the upper left triangle at the top in the middle, which is highlighted again in this visual, is removed. It was part of the original plans, and then of course it was removed over time. That one is more consistent through the plans to be no longer an area within the scope of this development. However, there is a new area that's come into play, and we are suggesting that this is a significant amendment when you change the area of the development you're applying for. The area that's highlighted in the middle, that's yellow, is a brand new area, and it's not consistently shown in the plans, but it is a brand new area. So the next slide will help show this as well. The next slide is in record page 23. I think this is really helpful, this slide. I will say that the yellow are my annotations, and you can see the changes, and not just, again, with respect to the plans and the building, but also just the scope of what they applied for. We see that in this plan, there is no longer, there's background for what was in the original plan. There's a lot of red, which also demonstrates the number of changes. The yellow annotations are, again, ours. So the trees that run along Silvertip Trail, those yellow dots, are all removed now. The path, that is the yellow line that runs along Silvertip Trail, is all removed now. The upper left-hand corner, which is a triangle, that is more or less consistently removed from the plans now. And then there's the new area that's in the lower middle left, and that's a brand new area. So again, we're suggesting that a number of things have been changed, but they are not evident in the advertising and not evident in the CPC materials, and therefore we suggest that this needs a new application. Next slide, please. And you will see from current plans of the items that I talked about, there is no longer indicated a path, there's no longer indicated any screening trees. And again, this is a current plan. And the upper left-hand corner plan area has been taken out. And you'll notice an inconsistency in plans because some plans show that middle, new middle area on the left as being within the plan area, and then other plans don't, like this one. So it's inconsistency with respect to the plan area itself. Again, this is a record page number 22, if I didn't mention that. So overall, we support, I support co-council's recommendation to this needs a new DP because of the extent of changes, or suggesting they're not minor. And I'll just read from our submission with respect to the summary of changes. We've got A, it's 55A of our submission. It's removal of the pathway from the plans without a replacement design, which increases uncertainty as to whether the directions of council have been met. B, removal of tree screening along Silvertip Trail. And I apologize, if you want to follow this within the record, it is page, it's page 323 and 324 of our submission. I'm on page 324, removal of trees without replacement design, increasing uncertainty as to whether context, massing, visual mitigation, pedestrian-oriented requirements, and directions of council are met. C, removal of the pathway and tree screening are similarly removed from cross sections. So we do not know how the municipal improvements are going to be accommodated between the spa buildings out to the median of Silvertip Trail. And it continues to have uncertainty as to what design options are available to accommodate the required improvements. Item number D, as I mentioned, the removal of the triangular area from the plan area of development. And it's merged now, taken out, and merged now with an area that's called hotel expansion. E, there's addition of a new connection area in the middle of the plans. That's brand new and wasn't within the scope of the application previously. And then F, with respect to building D, we have the removal of a mechanical area on the main floor of building D, and it's moved into the basement, and it's expanded footprint into the basement. We suggest that that's an intensity of use change because the main floor now has more room for public activities as opposed to mechanical. So we're suggesting there's a small change of intensity of use in that building. And then G would be the cancellation of the original development permit. Again, as co-counsel stated, the cancellation of the original development permit is an issue because the proposed amendments in this application rely upon that development permit to be in existence. So, and Ms. Stokes already covered that at length. So I will go into a few other of our items, and I will show some visuals as to where the directions of council are, and then how they are still not being followed, or it is impossible to determine how they're going to be followed, which we suggest is inappropriate. Next slide. As mentioned previous, the pathway has been removed. Again, that's a requirement in the direct control district that a pedestrian-oriented streetscape be provided. That first quote is from the part of the DC bylaw. It is at page 491 of the record. And that is the primary one that requires the pathway be in existence. The second quote is from the MDP, and we have quoted that in our submissions, and it is that pedestrian infrastructure be required so that it can provide additional connectivity. Next slide. The requirement to provide a designed pathway is also part of the conditions of approval, and we'll get into the effectiveness of the development authority, or development agreement, my apologies, with respect to ensuring that directions of council are met. And Ms. Stokes covered this condition in some detail, but nonetheless, it is from the SDAB conditions previously, and, it's an amendment from the SDAB conditions previously, and this is a new number 19. But nonetheless, it is a confirmation, if you will, that the pathway is required, and thus we're saying with the pathway now removed that we're not consistently putting together a way to get the pathway actually designed on plans and the screening trees, etc. So next slide, please. With respect to the screening trees, and this quote is from page 491 and 492 of the materials, it suggests within this section of the direct control that a visual impact assessment is required to show that impacts of building articulation, impacts of massing are addressed. The applicant has removed the pathway and the screening trees and has not provided a new visual impact assessment as would be required by this DC clause, and this is again not following the directions of council. Removal of the screening trees is a significant change to the impact assessment along Silvertip Trail, and is required by this section of the direct control bylaw. Yes, and so again, we're suggesting that the removal of the path and then also the removal of the screening trees is not continuing to not follow the directions of the council. In particular, on this one, a new visual impact assessment would be and should be required. Next slide, please. With respect to trees on the property, and it is significant because we're asking for screening trees, I think it's important to go through what was on the property, and therefore why we're suggesting that the original context, the original tree characterization of the area should be at least replaced in some form, and to be consistent with the Silvertip Trail experience going up to, Silvertip Trail experience going up to the resort. This is an image. It is at page 334 of the SDAB, or of this record, and it shows what the site looked like prior to any construction by Base Camp, and it does show a number of trees that are not only on site but also within the road right-of-way. They have all been removed, but I will show you where the property line is with the next slide so you can see which trees were removed. So this is a visual from record page number 135. I've highlighted in yellow the trees that were removed in part of the road right-of-way, which we consider to be important for purposes of mitigating massing, etc., along that portion of Silvertip Trail. And it The rest of the diagram or plan shows in crosshatch other areas, but the more significant were the trees along the road right-of-way area. So not only were trees removed within site, all the trees were removed along the road. And those would have typically provided mitigation for massing and at least potential for a pedestrian-oriented environment. I'll turn you to the next page, which is record page number 335. That is the current status of the site. So all the trees have been removed along Silvertip Trail, and no allocation has been made for replacing those trees, which would have provided consistent context along Silvertip Trail, and why the screening trees that we have been requesting are so important, because it has basically been cleared entirely along the area of the spa, and there is no mitigation anymore for massing or providing a pedestrian environment along that Silvertip Trail. We'll turn to the next slide. This is at record page number 69. This is a visual showing what actually was proposed earlier on, which is a diagram showing where the path would go, where some of the mitigation trees, screening trees would be planted. Again, the path and the trees in this plan have all been removed. Next page, please. This is a visual that was provided, record 1029. This is somewhat of the visual that was expected to take place along Silvertip Trail in terms of what might be accommodated along there. You will see on the right-hand side that trees were intended to follow along Silvertip Trail to not only screen the development, but also to help provide a pedestrian-oriented environment. Next slide, please. And again, this is at record page 22. It's just showing where the trees and where the path was, and that this plan, amended DP plan, no longer accommodates that within the plans or within the cross sections, and there's no visual impact assessment without the trees, which we say, all of which do not follow the directions of council. And next page. And this is from excerpt from record page 1026. These are some of the important trees that we suggest have now been removed, and that this visual assessment is no longer reflective of what the current proposal is. Next page, please. With this visual, which is again taken from plan and building design as visuals as part of the record. This visual shows the change to the massing along Silvertip Trail, and this is where the trees have been removed. So we're suggesting that this proposal now, with no trees along that side of the elevation, is not consistent with what the context is not consistent with providing a pedestrian-oriented environment, and is not providing appropriate screening for the massing. And so this wall of building materials is all that you will have in front of Silvertip Trail experience. And some of the other visuals in the that I've shown you and or will show you show that there's an extensive amount of trees along here originally. And so we're asking for screening trees, we're asking for the path, we're asking for that to all be properly accommodated now to meet the directions of council. Next page, please. Just so we can, I'll take you through in 3 slides here. This is the only, these are the only visuals that are really brand new, but they are just photographs. They shouldn't be hard to review in terms of time. But the upper left-hand corner is what the original landscaping looked like, and the lower right-hand corner is that landscape right now with some construction stockpiling, of course, and then with the complete removal of trees. Again, on-site trees with development, it's common to remove them. We've got a lot of trees that were in the road right-of-way as well that were removed, and nothing is being replaced along there. Next slide, please. And this is, again, just another visual looking up Silvertip Trail. Upper left-hand corner is what it was like, as close to the power line right-of-way, and you can see in the lower right-hand corner, nothing left along Silvertip Trail. Next slide, please. And again, just another view up the road. This to me, in the upper left-hand corner, establishes context and what one might experience as a pedestrian and or driver going up to Silvertip and through the area. And below the diagram is current, or photograph is current, and it shows that the all of that vegetation has been removed without any replacement. Next slide, please. Okay. So we've got, in sum, when I thought of what this planning situation looks like to me and the development, we've got no trees for screening or replacement, but we've got trees internally to the site. So what we're asking for is the public interface of these buildings against Silvertip Trail changes the character, changes the context, and we have no certainty as to the mitigation measures that are being used to account for the extent of massing along Silvertip Trail. There's some suggestion that there would be shrubs planted that can be accommodated within the drainage right-of-way, but we're suggesting that that just isn't enough. It doesn't provide appropriate screening. Next page, please. Sorry.
One moment, please. We have a question. Go ahead.
If possible, before we move on to the next sections, can we ask questions on the pathway and the tree screening, if possible?
Absolutely. I don't have any
Is that-
problem. It would be through the chair,
Through the chair?
if that's
I
appropriate.
mean, through the chair.
Yeah, go ahead, please.
Just to capture some of these questions now, before we get too far, just so they're fresh, because I feel like I'm not quite understanding something. The pathway and the trees are off-site public realm improvements, correct?
Through the chair, they're actually not all off-site improvements. So what Ms. Stokes in the prior presentation presented was typically the pathway would be accommodated entirely within your site. You're required to provide it. Now, this pathway that is designed is cannot, I'll show in later slides. The pathway, you've got to take 1.5 meters from the buildings, which has to be pretty much gravel because of fire smart. Then you've got a drainage swale. And then you've got the pathway. And then you've got a number of municipal improvements, and then you get out to the road. So I will show you a cross section a little bit later on, but there's a lot to account for within the area.
That is correct, And I believe through the chair, you said there's no certainty around what that might look like, but I thought that we have engineering and design guidelines for public realm improvements. So isn't that certainty around how these things get designed?
Yeah, and I'll get to that in a moment because that comes up in the development agreement portion. I don't disagree with you.
Okay.
What we're suggesting, though, is that design should be before us today.
Okay.
So what?
And it gets to my question in the sense that what I hear you saying is there's no pathway, there's no trees, but there's just no pathway and no trees in the plans that are submitted. And what I understand is that that design is subject to a development, to an agreement between the town and the applicant as part of the conditions of approval. And so the original, like the first time around, the design of that area was included in the plans. And this time around, the design of that area is not included in the plans. It's not, we're not saying it's not happening. It's it's my understanding that a trail will happen. It's just they're not included in the designs that you're seeing in front of you right now. Is that, because when you say there's no trail, it makes it sound like that no trail will ever get built. But I don't think that is that what you're saying?
That is what we're saying.
That
We're
no trail
saying
will
it's
ever
a
get built.
possibility that no trail will ever get built. The development agreement contemplates, and I should discuss this when it comes up to the slide, but I will give you a little bit of intro on that, is the conceptual design and the actual final design is contemplated in the development agreement. However, we've gone past one of the deadlines already. Then there is the opportunity for cash in lieu. But what this doesn't help us with is actually determining and confirming that directions of council are met. It doesn't necessarily require at the end of the day that improvements will get built that meet the directions of council, because we don't have a design for it. So we're kind of cart before the horse kind of thing, or
but when there is a condition that states that the applicant and the town will enter into an agreement to do something, has that ever not happened before?
Oh, for sure.
Yeah, okay.
For sure. Not all conditions, I've been doing this for 24 years, 20
Right.
years
Okay.
probably full time. Not all conditions of a development permit are met, especially when things are negotiated between the town and the applicant, and affected parties are not, do not have any input into that. And I would say that for an item, when I first came onto this file, which was only a couple months ago, for this item to still be discussed without a design suggests to me there's a problem. Okay. Because to me, when I came onto this file, and I have an architecture urban planning background as well as doing this from the legal perspective, first thing was, why isn't this designed yet? And then we found the development agreement registered on title, and we found that, well, the town was actually supposed to design it. And then we're supposed to have a final design, and then money was supposed to be put aside. None of that happened. So I hope it answers some of your questions. I
hear that through the chair, what I'm hearing is that the question is of whether or not the intent of there being active transportation, which is a direction of council, to be met through what has been approved, is in question in your mind.
Absolutely in
Okay.
question, absolutely
Okay.
uncertain, and within a document that doesn't necessarily make sure it occurs.
Okay, and then my next question is with respect to the photographs you had shown along Silvertip Trail. Now, it's my assumption that under construction, there's no screening or landscaping, and that what we would see along that route once it was completed would look differently than what you were showing. So I'm wondering what is the value of the photos in terms of views, because it's not done.
Sure, the views are to show context. So it's to show that at one point we had a context with consistent landscaping along Silvertip Trail. And it is correct, they are mid-construction at this point in time. Was it necessary to take all the trees out of the road right-of-way? No. It may have been cheaper, it may have been necessary for certain items, but at the end of the day, the fact is that everything was taken away and nothing is necessarily being put back in with certainty so that we can evaluate whether the directions of council are met, because we don't have a design.
Okay, and then the consistency of the images to me is challenging, because some of them are in winter and some of them are in summer. And so were there, that's just just a point for me. And then I did have a question because I was under the impression that site grading and tree removal was a different development permit.
It absolutely is a different development permit, but it doesn't necessarily mean that all of the trees within the road right-of-way had to be removed. Part of the reason for removal, I imagine, is that they're conifers. And in order to have conifers next to a building, I believe there's a 10-meter fire smart setback. So when co-counsel referred previously to the reason why we're here today is because the buildings were pushed so far up against Silvertip Trail that you then have to start removing stuff. So if you're going to start removing stuff, then replace it with the screening and the pathway, etc. So moving the buildings closer into the site, I realize the site is tight. However, one of our arguments within our submission is that original plans of the spa had the spa continuing over into the hotel expansion area. So when the developer, I assume, decided that it was better to put most of the spa items within the triangular portion, the buildings were already designed fairly close to the property line, but it then meant there was no flexibility. They had to be next to the property line because it was so tight. When you moved the spa original design from 2023, I realize it's often conceptual designs at that time. That's now going for hotel expansion. So you've got the spa tightening up on a very small site, pushing it out as far as possible. And then the municipal improvements that you would normally include on your property as required, which is room for the pathway, is now being pushed onto municipal property.
And all of those changes were done prior to the approval. The actual approval of the first DP is where it is located in this DP, correct?
Sorry, all of the changes, which
Like
changes,
in terms
sorry,
of
through the chair.
like where those buildings are situated in relation to the edge of the property and the public realm, like that wasn't a change. Was that an amendment in this, for this one, or is that what was approved?
No, that's the reason we raise that is simply because, in our opinion, had the site been designed differently, we wouldn't be pushing all these municipal required improvements into the municipal right-of-way. They would have been included normally on the property.
Awesome. And then I have one question that through the chair might be for administration. I do know that we have a tree bylaw that requires that when trees are removed from public spaces that they are replaced somehow. And I just was hoping maybe that is something, maybe that might be something that administration could bring back later in the meeting if that is helpful information, because what I hear you saying is that these trees have been removed and there's nothing to say that they're going to be replaced, but there might be. And so I'd like to see if that does exist first. Thanks.
Would admin like to respond to that?
There we go. Okay. Yes, so there is a tree protection program with parks, and that is something they look at removal of trees and replacing trees, as well as any future pathway designs would include that type of material as well.
Thank you. Thank you.
Okay, thank you. Please proceed.
Okay. The other area of screening would, of course, be the parking areas, and that's discussed in our in our submission as well. And I've just indicated the quotes from the direct control bylaw that apply. And I will just take you to the next visual. And this is at record page 331. And this shows that the trees, or the parking areas, are indeed still not following the directions of council because there's no screening. Next slide. So the development agreement, and we did touch upon this previously. So we just came into being aware that a development agreement was actually signed and registered. It appears to have been signed in July, which means it would have been negotiated in June. This is not part of our knowledge at the last hearing. It just came to our attention recently. This is that record, the development agreement starts at record page 512. I'll take you to the next slide. I'm not going to read through the development agreement in detail, but there are a few clauses that are important, in particular 3.15 and 3.16. This development agreement, this particular page, can be found at page 527 of the record. And basically the development agreement, again, probably negotiated in June if it was signed in July. It was registered on title in August, and we just became aware of it in early January because we would have no reason to be looking at the title for the property, and we had no knowledge this had been negotiated between the town and Base Camp. What the development agreement essentially says in a nutshell is that the town will provide a design for the pathway and related municipal improvements by December 31st. So a conceptual design. And remember the timing of this agreement, 6 months. They've got 6 months to actually come up with a concept design. At that point, Base Camp would then be prepared to provide detailed design. Should the town not provide the concept design, Base Camp can provide cash in lieu. In this case, $400,000. To our knowledge, nothing occurred at the town's end from a concept plan perspective. Again, agreement signed in July, deadline December 31st. No concept plan produced. So at that point, of course, it's Base Camp's option to pay the $400,000 cash in lieu. So when questions were asked previously as to, well, it's a condition of approval, it will go into a development agreement, it will get done. Nothing has been done in terms of providing a concept design from the town, and therefore no detailed design. So a condition and a document relating to the condition is still sitting. And there have been discussions with the town and Base Camp to get some of this work done. This work and this question about how everything can fit has been on the table for 9 months. Again, development agreement signed in July, but it's literally been on the table for months. There is not even a conceptual design. We have learned recently within the last week that the town is committed to putting something together, but we're past the December 31st deadline. We're into cash in lieu. When we get into a cash in lieu situation, we have no idea whether it's going to be done then either. So what we're suggesting is that the condition, the development agreement, the way they're worded, and Base Camp and Stone Creek had no participation in any of that. We are still left with uncertainty as to what the design is going to be to accommodate the municipal improvements and the tree screening required by directions of council. In a perfect world, the development agreement would match the condition, the design would get done, and it would be all moving forward. But we are 9 months into this, and we still don't have a design that the town and our client has been able to look at to see if it accommodates what base camp's required to provide. And I'll turn you to the next page. It's, again, page 527, of the record. And again, this is just part, this slide and the next slide are just part of the development agreement conditions. It also does acknowledge that there's a Court of Appeal process ongoing, and that should base camp continue with construction and conditions from that and questions from that original development permit do result in a different decision through the Court of Appeal process, that base camp will be responsible for changing whatever they've designed to accommodate any any appeal decision that comes from the Court of Appeal. So essentially it's saying, base camp, you can proceed at your own risk, and the town is not liable. And the next page, and that's just further narrative, and that's from page 528 of the development agreement as well. So with respect to this slide, and I've shown it previously, it's at record 226, and I've highlighted it with yellow, is that we still are without assessment, the ability to assess whether directions of council are met and will be met through the development agreement and condition process, which is why we suggest that the detailed design, conceptual design and detailed design needs to be done through this process. The SDAB then can memorialize what's been designed. We can additionally show or not show that directions of council have been followed. I can say that because our client has been unable to make movement with respect to this particular item and to get certainty, we did within the last few weeks come up with a proposal for a design. And we were originally told, don't bother designing what the town needs to design, but we weren't getting anywhere. So I suggested to the client, let's try. Let's put something forward to show what possibly can be put within the cross-section of the lands that we're looking at. And so I'll take you to the next slide. And this is from our client, Stone Creek. It's at page 673 of the record. And it's simply showing a cross-section of all the items that need to be included within the, from the base camp spa buildings all the way out to the median. And we have probably about, 5, 6, 7 different things that need to be included in that cross section. So we wanted to get the discussion going. But in answer to questions that were previously put before myself is, this is the design work we're looking for. This will help establish whether directions of council are followed or not, and we suggest that this is the type of design work and clarity that this board needs, because without it, it is our submission that the directions of council have not been followed. We have been sitting with conditions and a development agreement for months and months and months and months without any progress. And this is the conceptual design and final design, or this is conceptual design at this point. This is a sample. We put it forward to the town. They have looked at it, and they are now coming back with some comments on it, and their own McElhaney is putting together some plans. So I think that's important for the board to know. But this is the type of diagram and information that would be important to condition, that would be important to ensure it gets into a development agreement, and that important to ensure that it actually gets built. Whether it gets built today or 6 months from now, or 2 years from now. At least we know what's going to get built, and therefore we know that directions of council have been followed. I will take you to the next slide, which is a conceptual design of a cross-section through the portion that's just off of Palliser Trail. And that too is, again, a conceptual design drawn up by our client in-house, just to show the possibility of how you can keep the path, how you can put the retaining tree or the screening trees in. We're trying to suggest there are options here, and we're trying to spur the finalization, if you will, of the design so we can ensure directions of council are met. I've just got one more slide left, 2 more. Next slide. This is presented by co-counsel previously. These are the questions that are going before the Court of Appeal, and we continue to advance these particular items, and we'll be prepared to move forward with that. We are hoping that as part of this process we can tidy up all those loose ends, but we are still missing certainty that directions of council will be met. In conclusion, we have a few options. Require a new development permit covering the entire development, not just the amendments, as we've suggested. The second is to adjourn to obtain the full record, re-advertise, and get clear plans. And then, sorry if I said this third one, second. And the third one is proceed, and we have established that base camp has not followed the directions of council. And those are my submissions, subject to further comment from co-counsel. Seems to be okay.
Thank you. At this time, any questions from the board members for clarification? Yes. Bryce?
I have a question. It's maybe for administration more than for you. Thanks for your presentation. Is it correct that there's a development agreement being signed by the town July 18th or so?
That is correct. There is a development agreement for the previous DP that was signed, and for this DP it would be irrelevant because a new development agreement would have to be signed for this specific development permit under appeal currently.
Okay. And then we learned that the design has not been provided by December 31st, 2024. Is that correct?
That is correct, and we did not pursue completing that clause within the development agreement because we had already received a new development permit application, which triggers a new development agreement.
Okay, thank you.
I have a question for administration as well. Just for clarity on design requirements and some of the things we've pointed out in the appellant's presentation. Has the applicant been meeting your requirements for timelines and those requirements for submissions and things of that nature?
For application submissions?
Yes.
Yes.
Okay, so your requirements are currently met on the part of the applicant. You're satisfied with those requirements at this time?
Correct.
Okay, thank you. No further questions from you. Okay. Any? Thank you, development. Is the applicant prepared to proceed?
For the applicant, Mr. Fisecki will speak first, but I just want to clarify that that will be the order that will go in. And given that we have an hour before a lunch break, I'm wondering, depending on the length of Mr. Fisecki's presentation, if we might, if it goes to noon, then my point is I don't want my presentation to be interrupted by the lunch break. So at the, obviously the discretion of the board, if we get to that point where it's close, could we call an adjournment for the lunch break before I proceed? And also, we'd like a 5-minute break right now if we could.
Both of those are reasonable asks, so we'll recess for a few minutes to allow the applicant to prepare, and we'll address the timeline as we go. I can assure you, you'll have an opportunity to complete. Okay, thank you. We'll stand adjourned. resume and allow the applicant to make their presentation, please, if they're ready to go.
Good morning. For the record, my name is Biral Fazeki. I'm with Base Camp Resorts. Thank you again for your time today. It's been a long morning already. I have a lot to say, and I know my father, who's passed, he raised me saying you have to stand up for those that don't have the voice. He also taught me a lot about integrity, which ties into professional integrity. And I heard a lot this morning, which was exceptionally disappointing, and I just can't let go, and I have to say it on the record, that make no doubt there has been an abuse of the SDAB process. In fact, it's quite disheartening. I heard a lot of comments about staff mistakes and what staff didn't do, or what they didn't do appropriately. They've been excellent. And that needs to be stated. And I'm hoping that through my presentation that we're going to see that it all boils down to one primary issue. And I'm saddened that we've had to cloud that one primary issue with all these peripheral points. And I get it. I'm not fresh, out of bed. I've been in business a while, but man, I feel that I had to make that one statement. So let me take you through some slides on that point. We received our first DP approval by CPC on February 21st, 2024, basically a year ago. That approval was upheld by SDAB. There was some changes, as we all may recall, or some may recall. We all know that Stone Creek was able to escalate that to the Alberta Court of Appeals. And my view of that escalation and my interpretation of that escalation was on one primary issue, the issue of the pathway, that off-site condition that was imposed on our first DP. So let's be really, in my view, I want to be clear about that. Stone Creek went on record even in the public newspaper in April 29th, 2024 at on the Rocky View Mountain Outlook. They did not, after 15 pages, their then counsel stated, in summary, our client is very supportive of this development. We just need a bit of time to get things sorted out. Now there was a full and wholesome commitment to sort it out through the summer. Both sides spent extensive dollars in time. We spent extensive dollars with our consultants. And we had one focus in mind: to please and appease our adjacent neighbor. I have great respect for Mr. Turcotte. We travel in the same social circles. We share some investors. We know each other. So it's very difficult today to be here and to have such frustration towards his council and the direction that they've been given. But I'll get off that pedestal, I promise. I'm almost over it. I'm on my third slide here. So let's talk about August 6th. Because I also heard today that they had no awareness of all the changes that were coming down the pipeline, and they were left in the dark, and that was an intentional strategy, and we somehow messed up between an amending DP, between a new DP, and it was all quite intentional, and it was all done in the dark. It wasn't done in the dark. And I'm hoping over the next couple of slides you'll also see that. So this slide has a lot of hand markings on it. On the right-hand side, you see the August 6th slide. On the left side, it is the previous approved DP. Clearly, they are different site plans. I will be showing you that while they're different site plans, they are really, really minor in the actual intent and the impact to the greater area. So while they're accretive to the project itself, and certainly for the experience of our guests that will come to the hotel and enjoy the spa, to the greater world around the hotel, they're not big deals, and I'm pretty sure I'll be able to show you that. So since the April date, we arrived by August at this plan. Now, this plan was presented to Mr. Turcotte himself, and I'm hoping we will get a presentation perhaps from Guy as well. But this was presented by a joint and mutual friend of ours, Ken Hughes. Again, no one should have, no small town should have developers fighting with one another. So there's a lot of effort to try to just get this sorted out. And again, a lot of effort by staff. They were there when we asked them to be there, both parties. There were not individual meetings, to be clear. I also presented this plan to the then VP of Development, Karen Finley. I walked her through what we were doing. I then called her on Tuesday, so 2 days ago, to say, Karen, I need you to just refresh your memory on our discussions that we had last summer. Did I show you the plans? Did I talk through what we were doing? She goes, yeah, absolutely. So I think that's an important point here. So while Ms. Anderson might be new to the file, and I'm going to be showing you that this is not new items coming to Stone Creek. From August 6th to September 9th, you can see here that the plan has actually been advanced, removing the handwritten comments, and we've actually converted to AutoCAD. So again, I am asking for a leap by this board to believe that we wouldn't spend the money on AutoCAD drawings if we didn't get some suggestion that we're heading in the right direction. Now, there's two key takeaways I'm hoping you get from this. First is, as I've already said, that Stone Creek is and was clearly aware that change was afoot. The second key takeaway is that ultimately it came down to, and I'm going to show this in a couple of more slides, the fact of this off-site condition that was imposed on that first DP. And I truly hope what you'll hear today is a comment of, get that off your plan, and I have no issue with the spot. I hope we hear that today. So that was the impetus to this drawing. It was getting that off-site condition off our plan to avoid the conflict. And in place of that, to create the assurances, was a $400,000 security posted and paid, it's with the town right now, to ensure that future bylaws will be followed when it comes to the design and the execution of the pathway. We have to keep in mind that Mr. Turcotte does have development ambitions up in Silvertip that will require pathways as well. So it's, you know, again, to the credit of staff, you don't want to work in just a simple vacuum. You want to see how it all ties together. But again, to the credit of staff, they made assurances that they had the money, and it's not taxpayers' money, it was base camp's money, because that was our responsibility to cover the cost of costs that are adjacent to our site. So through the series of discussions and the challenges, like we've heard, and correctly, we've heard about the challenges of the offsite condition, whether it's gas lines, whether it's water lines, whether it's fire smart, whether it's the removal of a lane, whether it's adding of a multimodal pathway. It just got very convoluted. And base camp, we kept saying to both town officials and Mr. Turcotte and his team is, we're agnostic. It's an off-site condition, which, you know, I take a firm belief that when it comes to community development, that it's not to a personal private parcel. That's the town's prerogative. I shouldn't be in their kitchen telling them how to design a public walkway or how to appropriately tree a public pathway. I have to trust them. That's why we pay tax-paying dollars. So I simply said, look, whatever you guys want, don't have it cost more than our security. Past that point, just let me know. If you want us to build it, fine. If you don't want us to build it, fine. But what we wanted to emphasize that this is an issue at the time of a pathway, that's all. And I think if we were to go through the records close enough, and I think just the articles you're gonna see, again, whatever you heard today, they're all peripheral, they're unnecessary pieces of data which have no impact to the true concern of an off-site pathway, removing a lane leading up to Silvertip. So with this change of removing, if I can get to that page, of removing the condition from our DP, it satisfied the condition of knowing that a pathway, the design of the path, we really couldn't land on the design of the pathway, and it's not as easy as Ms. Anderson was trying to portray, because mainly because of an email that both Guy and I, so I believe I can show this publicly, as well as some other members of the town, received from Andy, the manager of engineering. As you clearly see, Andy was doing all the right things here. He was ensuring that dollars were assigned. He was identifying quite clearly in writing that there's no capital project for the next 6 years for this pathway, because there's other things in motion. Now, the town has a multimodal pathway strategy, which has always been referenced. There was a time that we just all thought that we could have built it and it would have made a lot of sense and would have been okay, and it wouldn't have been a problem. But I think what happened, and I can't speak for the town, but I think what happened was, as the conflict continued, the easiest way was, okay, we're not going to get this built in an accelerated fashion. Let's simply have it removed. And by having it removed, we'll have the dollars posted. We're going to deal with it appropriately. And by the way, when I say appropriately, it includes a very clear public process and a budgeting process that engages the public. And Mr. Turcotte and his team would definitely have the ability to deal with it then. So I'm not sure, still a little bit confused on now why the urgency, but I appreciate the sense to want to know what it looks like. I live in Calgary. I would love to know what my neighbor's plans are beside me, because I know he's going to tear down his house, but I don't have to wait till he actually draws something. So I don't think it's, the sense that the house is on fire and we need to know what the design looks like doesn't make a lot of sense for me, but again, I'll leave it at that. So, again, I'm hoping that I'm showing or establishing that Ms. Anderson stated that they had no participation or no knowledge prior to December 18th. The email that I just showed you from Andy was dated December 18th. So clearly the parties up to that point were working hard together, and we're committed together, and I still remain committed to Mr. Turcotte. I mean, we want to be great neighbors. We're helping develop this great town. So we'll see how that goes after this hearing, I guess. But let's talk about each individual change, because seeing a plan that's all highlighted in red with lots of red lines, I agree, it looks convoluted. But let's kind of walk through them, if you will. I do believe, by the way, that the CPC did receive a full set of plans, but I think that's neither here nor there, again, because when I reviewed what Annika had shown us from an amending DP to a new DP, the most critical piece to that, so we can debate between the two variances, but the most critical piece is they both had the exact same public outward bound period of circulation and notification. So, the fact that there's some internal and external circulations that may have been skipped over because the file was so fresh, I don't know. Again, I leave that to the town's discretion. I certainly didn't have an opinion on whether you call it an amended or a new. But so the changes specifically, I'm going to go by them one by one. The first one is the removal of the lane closure. Again, I had assumed that when the town actually agreed that we could remove it and post the security, I thought we were done with it. I thought it was fabulous. I thought Mr. Turcotte would love to hear that because it took away his biggest concern. I will come to screening, by the way. Next, Ms. Anderson showed us a picture. You may recall this picture, and I had no issue with that obviously being added to the record, because the outcome of what you see here between the current DP and the previous was a direct response to their feedback. 100%. That was originally, as you can see on the previous, it was a straight wooden fence that went on the plan left side to the first building, and then between those two buildings. And the request was simple: we want different materiality, and we don't want it to feel like when you're driving up Silvertip that there's a wall of wooden fence. So we took the first portion and we actually made it a not chain link fence, but a square broadlink fence that you see like a wildlife fence. And that was done because we know we can do planting in and around that fence, so you have some depth to the property. And we also then pulled it into the site. So yes, there was a change in that sense, but again, totally accretive to concerns that was posted at the time by the Silvertip team. And then as far as the portion between the two buildings, that became a gabion wall, a rock wall, not a fence. So a much more expensive treatment, but again, accretive to the requests of our neighbor. They wanted some variation. We complied with that. So Ms. Anderson pointed out that there was a new portion of our plan that was so significant that we needed to address it as a new DP and have full circulation. Well, what triggered that was actually an SDAB change that was driven by, again, the team at Silvertip, because they didn't want us to access our site from that entryway. So we had to put a gate on that, and it was for emergency access only for fire and EMS. In doing so, we couldn't supply those buildings with the appropriate chemicals for our pools, so we had to have an internal path. Well, we needed to connect to the site, and that's what that was. So I think I would argue that that is a very benign and minor change. There was a ripple-on effect of something that was imposed on us, which we accepted. We also, I did notice Ms. Anderson in her plan highlighted some of the trees that we added. And again, I think that's fantastically accretive. You can see them around the parking area. I didn't highlight them here at the top of our site, but those are clearly new trees. Because we're building a Nordic spa, we want trees. We do have a site constraint, and I'll talk about those in a bit. Now, some other minor revisions. I believe Ms. Anderson is also an architect, so I lean on that expertise. Our sites, all our buildings are located with the appropriate setbacks. The pathway which she referenced is leaning onto public lands and not within our own. That was not an outcome of site constraints. That was an outcome of a request to have some more screening adjacent to our buildings. The town was willing to allow us to push that pathway design into the kind of, so it straddles both the private, so our right-of-way behind our buildings on our parcel, and the public right-of-way. So there were, to the extent the council is interested, like there's probably north of 100 emails that have gone back and forth since last February. So we did change the configuration of the pools, as you see here. I hope when you just, at a raw glance at this plan, what you're seeing is you're seeing the reduction of hard surfaces. So intuitively, as you reduce hard surfaces, you actually reduce the amount of people that can be on the site at once, right? Because they're not going to sit on plants and on top of green shrubs. I'm hoping that's the image you're getting from this, because that certainly was the intent. Part of the redesign of the pools were twofold, again, to make them more accepting for our guest visitations, and also bluntly and frankly, the cost of maintenance when we had so many ins and outs on the previous pool layouts, our pool expert was quite concerned about the cost of maintenance for that, so we went to a simpler design. But again, the intent here, one of the key intents, were to reduce the hard surfaces in the site itself. You have to really focus, but the round circles are trees. You'll see that there's more trees planted on the current development permit than the previous. And Ms. Anderson was not totally correct. Her statement was correct to say, well, they're planting trees on the inside. Why can't they plant them on the outside? Our site's actually really restricted. It is a triangular site. We do have the right-of-way in between, so we have to be very respectful of the utility that goes through that corridor. So the site challenges meant that we couldn't plant as many trees as we wanted. Through this redesign, as you will see, we clearly can plant a lot more trees. We also removed 8 pods and pathways and replaced them with the 3 pods here, the 3 tents that you see on site. And again, that was to ensure that we can do more planting on the utility right-of-way. And it also meant that in the event, by the way, the utility company was comfortable with either plan, but it certainly made the ability to, if we had to take down a tent and put it back up, it made it really easy to do. Also creates a better guest experience. We've added 2 more barrel saunas. We changed the fire pit locations. The building footprints remained unchanged for 3 of the buildings, and there was a slight change which I'll separately address. But what did change, so building A was a lounge and a food prep area. Now it's a salt sauna. Building B was unchanged. It's an experience sauna and will remain an experience sauna. And what I mean by experience sauna, we bring in specialists that do rituals in the sauna. So it's not just a very passive process. You actually, I won't bore you with those details, sorry. Building C is unchanged and it was a steam bath and it still is a steam bath. Building D was various spa experiences and now it's the relaxation lounge. So the key reason, so you'll see with Building D, there were spa experiences inside. The reason we switched it to a relaxation lounge was not to increase the amount of flow into that area, but it's to increase the ability for our guests in the wintertime when it is -30 to have more space to relax and not feel they have to, prematurely leave the spa experience. When it comes to the buildings themselves, we changed the exterior materials. There were comments in earlier discussions that they were too generic, so we did change the treatment of the exterior building. We also received a comment from the Stone Creek team that they didn't like the fact we had a sign promoting the spa on the exterior of the building as you drive up Silvertip. So as you see from the current DP, we actually removed that sign. On Building A, again, this was the lounge, and now it became a sauna, so we had to reduce the amount of glazing. Again, internal to the site, so I'm finding it really hard to believe that is a major change because it doesn't impact the peripheral areas. Again, there were some treatment changes to the materials used on this building. Again, changes to the materials used on this building, all accretive to the architectural guidelines of the town. Changes to the, and this one again was an attempt to please our neighbors up the road by changing by creating a variation in the building plane itself. It breaks up the eye, breaks up the plane. Similar thing, just keeping with theme of its designs. Please forgive me and thank you for indulging me on these minor changes. Similar thing here, a little bit glazing change. I will pick up the pace. I hope I'm clear on my messaging here. So I did mention that there was one building that changed in footprint size. That is an exceptionally minor change, again, as you see here. And that was to accommodate the fact that when SDAB restricted the entrance for supplies at the top of our site, and we had to create that internal pathway, well, we had to access the building because there's a massive grade change. So we couldn't get back to the top from the inside of our site, so we actually had to create a stairwell at the bottom corner of the building, and that was that bump out there. I am getting close to closing. So I would argue the Stone Creek was aware of the changes, and I'm sure they felt like I did, that they are benign to the impact of their area. So I'll leave that. But I also believe that the town was within its authority when they outlined the process to remove the offsite condition, because the bylaw secures the town's ability to create a pathway if and when it's ready to build one, if and when they understand what Silvertip will be doing up the hill, and if and when they've completed a public outreach. We will continue to work through this. Ms. Anderson was quite correct in saying that I think we're darn close, but I don't think I'm allowed to speak to that. But I do believe we're, this may be a moot point at the end of all this, and I'll tell you why I'm concerned about this process, because I don't want it to be a moot point. Here you see again in another publication, and it's not to throw at Stone Creek, but it's to emphasize that again they don't have an issue with the Nordic Spa. So I am pleading with you today to kind of uphold our approval. If there is a concern, I do want to touch briefly on some of the comments around screening. If there is a concern about the screening piece on public lands, and we can go into great detail about that to the extent it's necessary, this board has the authority to put that on the plans today. Which both sides would welcome, frankly. We know that the security is there. So again, I feel a little bit of the screening issue being a red herring, but I will come back to that because I wrote some other notes. I'll end with I'll end with first an apology to Mr. Turcotte, because I do have amazing respect for him. But it's also when I said earlier in my presentation, I called the abuse of the process was not from us. And so I want to end with one image, which is a terrible image. I used it last time, but it emphasizes how silly things are getting, because this is all about the lane closure, and that's all. They talk about screening. Well, this is a public roadway, and that in front of the parking lot up at Silvertip. So I recall having more trees than that right now today. So I'm really confused why they're picking on base camp to the extent they have about our screening when they're not willing to do it on their own lands. So again, I say that out of respect, and a quick apology to Guy about that. But I think council, well, I'll leave it at that. Let's talk about council's couple of comments. I'll get that picture off the image and turn you to a more pleasant picture. How about that?
I think we have a, sorry to interrupt there, but I think we have a question. Okay, please proceed.
Thank you.
Thanks.
So just briefly, we know that tree screening can be added. We in this proceeding, if you so choose. We know that the security has been posted. When we talk about impact of screening, there's a lot of detail that was provided in the previous hearing that we had. Some of the reasons we did the roof articulations, in sense, is to break up that mundanity of a visual sight line. We broke up the fence lines. We do have to deal with fire smart, which is a true challenge. And the reason we removed all the trees is simply because we had to put a water line through there. So there was no preservation of trees. And again, I would argue that this was known. But again, I do respect the fact that Ms. Anderson is new to the file, so she may not have been aware of that. That would have been just a simple question to me, and I would have been able to answer that. Regarding our design, respectfully, I do not go into Mr. Turcotte's sites and give my feedback on how he lays out his buildings. I would appreciate the same. As long as we're within bylaw, I don't know why Ms. Anderson is addressing that. But if she is going to address it, I think it needs to be addressed in the context of correctness. We were within our appropriate setbacks, and not as determined by the bylaw, but as correctly noted by town staff. So one comment that Ms. Anderson made was that no concept plan had been produced. Hopefully what I'm seeing was a great effort to produce plans. But more importantly than that, it was a true intent to create a plan. Mr. Turcotte knows that the money is there. We both agreed that the money is sufficient. The town has been working at reaching an amicable design, and hopefully we can, and hopefully it gets built with our site, because trust me, I don't want to build a spa and then have to go in and do a pathway 6 years from now. So it would be great for us to have it, and again, that's a tip of the hat and a credit to the town willingness to accommodate the fact that we're building a spa today. But I'm puzzled on the Ms. Anderson's framing of this situation. I don't think it was so underhanded as positioned. I think that's really it. If there's any questions, I'd be happy to answer them.
Thank you, Mr. Basecki, for your submissions. The development agreement with respect to the pathway design and the $400,000 cash in lieu, you referred to that as a security that the town already has. Is that different? Is cash in lieu different than a security?
So, no, sorry, it is our cash in lieu.
It is cash in lieu. And so the cash in lieu, that's a system where if something isn't actually built, the money is provided instead to build it at some time in the future. Is that correct?
Through the chair, that is correct.
Okay.
And that has been funded to the town. That is in the town's coffers.
And then you mentioned the tree removal for infrastructure. Are you aware of any agreements or conditions or intentions to replant those trees in the right of way, just in terms of if you had to take them out to put in a water line, once you put the water line in, do you put them back in?
Through the chair, the quick answer is absolutely. Every single plan, and there's been multiple plans since February since April, that we've been in discussions with Stone Creek. Every single plan has had a tree screening throughout the entire length of Silvertip within our property boundaries. Again, the challenge has been how do we deal with the gas line, the water line, fire smart, and the type of trees. And we, again, to the town's credit, the detail of design that they've gone through on what trees we can plant and where they can be planted, we have all, we're really, really close. My fear, if I was to use that word and share that word with you, is I want to believe at face value when I hear that no one has a concern with the spa, and I shouldn't be worried about our investment in the spa, and this is all about the off-site condition and the certainty around that. When I hear that, that's soothing. My fear is then I see actions like the presentation this morning, where, wait a minute, we're starting to throw everything, including the kitchen sink at this, and we're going backwards from stuff that we all know has nothing to do with these discussions. And that's the fear in me, because now I'm worried I have, okay, yeah, we do have a permit to do foundations. We've had to put those in because trade constraints, because the cost of money, as we're all well aware. We're a small company. We don't have deep coffers. So when I layer all that in, I say, okay, am I in a gunfight and I brought a knife? What am I missing here? And are we really going to SDAB no matter what?
I know.
Are we really going to the appeals court no matter what? And in that sense, I would rather put my trust and faith with this board and hopefully get an approval and an upholding of our DP, so I can continue on to a BP and just keep going while the Alberta Court of Appeals process just goes in the background. Or we reach an agreement. But at least I'm able to keep going with our development. That's why it's so important today.
Yeah. Basecamp has made a number of development permit applications on the site over the past few years. Given that the last development permit application is at the Court of Appeal, and that part of your submissions is that the amendment, which is in front of us today under appeal, was to address a number of the concerns of the appellant. Did you provide the appellant with information about the amendment in terms of the communications? When you talk about back and forth and a lot of goodwill and trying that, when that new application for amendments was made, was that communicated to that party?
So like anything in life, there'll be two versions. Mm-hmm. I'll give you mine. Okay. I would encourage that same question to go to Ms. Anderson and Guy. Absolutely. Because the presentation has and always has been, and there's multiple emails behind this, it is what is happening. And I think he's right. I respect the concern of you're removing a lane. I'll have one lane of traffic going up Silvertip. We have construction traffic. We have different speeds of vehicles. We got to get that off the plan. Just get that off the plan. That was always the focus. And then at one point, I think it was the town actually that came up with this. I thought it was quite brilliant. They realized that because the road standards have changed, there's enough room to maintain the 2 lanes going up. They would have to remove the berm that's in front of our hotel and push it all kind of into that site. And they've asked if we would have a concern with that, and I have publicly on the record said, no concern. If this is what it's gonna take to make this all go away, absolutely, we can remove that berm. So, to that extent, sorry, getting back to your original question, I believe wholeheartedly that I can show through a series of emails that everybody, the one primary issue was the lane closure, and that lane closure was dealt with and is being dealt with. It's being dealt with.
Well, I mean, it sounds like that there's clear communication about what the issues were. I was just wondering if there was direct communication from Basecamp to Silvertip that you had submitted a new application to amend your development permit.
Oh, no. There was not. There was the public process. But again, and it might have been a point of pride, so in hindsight, should I have? Absolutely. But life gets very busy, and you just, that's what the public process is. It's an advertised program.
That's all my questions, but through the chair, I just want to make one minor comment. I think some of the photos you showed may have not been appropriate because they're contextually not the same as your application. And so in the future, it would just be really good to stick to what we're talking about when it comes to submissions. Thank you.
Thank you.
Any further questions? Good. Thank you.
Yes, but I do have a presentation, but we are at noon. I'm asking if we can, so that I don't be, so I'm not interrupted, unless we want to defer the break until after. I may need an hour, perhaps.
Get a motion to recess for an hour for, okay. One moment. Go ahead.
Through the chair, we just have a request that we be able to be given a copy of the presentation that was just presented. We don't have it.
Okay.
Thank you.
Okay, we will recess for lunch, return at 1:15 p.m. Next, we are in the applicant's presentation. Is the applicant prepared to proceed?
Thank you.
Your mic's on now, thank you.
Leave it alone, you'll use it, okay. Mr. Chair, members of the board, Bob Homersham again on behalf of the applicant, referred to as Base Camp. The lands are held by Canmore Hotel and Spa General Partnership, but that's call it a related party to Base Camp. First want to begin with thank you. Okay, first want to begin with a housekeeping item. In my written submissions, I had referenced at footnote 4 some provisions or pages within planning law and practice in Alberta, the LOC's text, and I failed to include those in the written submissions. I've since provided copies of those to the clerk so that you could have those, and I've provided a copy to counsel for Stone Creek. Also, while we're doing housekeeping matters, I did notice a typo, or at least a missing word, in my written submissions, and this would be on page 257 of the agenda, paragraph 3, sub 2, which reads, the landscaping requirement under DC bylaw 0999 for the accessory use were not, and I've neglected the word met. So if you could make that note. Secondly, the counsel for the appellant, Stone Creek, had provided, had materials, a presentation to this board, which largely, I agree, relied on pages that were in the agenda already, and as was explained with some annotations, we don't object to those. So.
Thank you for clarifying those points.
With respect, I'm going to begin after that, those little housekeeping exercises, with a reminder of what the Development Authority stated when they presented first. There's been much made about an amended DP versus a new DP. This DP, I'll call it the 2024 DP, and the prior one, the 2023 DP. The Development Authority, through Ms. Drost, explained the difference between their processes for describing this as an amended DP application versus a new DP, which they would review from the start. They already had the benefit, the Planning Authority, the Planning Department, which is of course staffed by experts. They had the benefit of the first submission, the 2023 submission, which was complete, which was approved by CPC and then approved with amendments by this board. The 2024 DP captured requirements that this board imposed, further conditions, and also amendments, as Mr. Fisecki went through, almost entirely on-site to deal with some on-site constraints so that they could have a better development at the end. Those amendments, almost all of them on-site, the exception is the off-site pathway, which was removed. Those are well documented, and as we heard from Ms. Drost, there was a complete application. The 2024 DP, call it amended, call it new, it was a complete application before CPC. And as we heard, the notice requirement for that application was met. That's a notice posting on the site, I believe 10 days prior to the hearing, to the CPC hearing. It was also advertised on CPC's agenda. And as Mr. Fisecki had advised, he had also informally given notice to the appellant, Stone Creek, through one of their officers, a Karen Finley, that they were making amendments to the DP. So on January 13th, when the public hearing opened, I began to argue that this appeal should be dismissed on a summary basis for failing to make out any appealable issues. The board made the decision at that time to not hear those arguments and instead focused on the appellant's adjournment request, which brings us here today, and its allegation of bias or apprehension of bias against the panel, which the panel also ruled on. I advised appellant's counsel prior to the opening of this hearing on January 13th that I intended to seek summary dismissal of its appeal on the basis that its pleadings were deficient, that they failed to disclose even a single appealable issue or an issue that couldn't just be addressed summarily because the facts were clearly misstated or the law was misstated, or both. The appellant was present, of course, at that hearing, the opening of the hearing on January 13th, heard the beginnings of my arguments before this panel. The appellant is a sophisticated developer. It's represented by sophisticated legal counsel. They were all aware of the development approval process and the rights they had as an affected party. Their notice of appeal, their pleadings, were filed on December 17th, 7 weeks ago now. The adjournment request was theirs, and yet their pleadings remain unamended, without particulars. The appellant had ample time to amend its pleadings. It didn't, so they are stuck with them. Their pleadings, which are on page 38 of the agenda, the notice of appeal, are the pleadings before you. The 890, I believe that's the right number, 890 pages in your agenda that the appellant submitted, its written submissions comprise 75% of the 1,200 pages of the agenda. Those aren't pleadings. Those are their arguments. And we don't need to, the board, of course, is in charge of its own procedure, but we're not dealing with unsophisticated parties here. And notwithstanding my friend's argument that what I had raised in terms of a motion to strike or strike actions was with respect to a litigation where there's a statement of claim, pleadings through a statement of claim, that may or may not disclose a cause of action against the other party. The underlying principle is the same, whether you're dealing with a statement of claim and causes of action or grounds of appeal. You have to, at a basic level, describe your grounds of appeal with enough particularity that the opposite party, us, the respondent, knows what case they have to meet. We only knew that case that we had to meet with the written submissions, both of which, ours and theirs, were submitted concurrently in accordance with your processes. So that puts, because of the concurrent filings of the written submission, that puts even more of an onus on the appellant to provide pleadings that contain enough narrative, particulars, and material facts to clarify the issues that it is appealing and to allow us to respond to those issues. The DP applicant, my client, did not have the benefit of knowing the issues we needed to meet prior to preparing its written submissions. Specifically, the last two issues pleaded by the appellant in its notice of appeal, and those are at number 5 and then the last paragraph on page 38, I believe, of the notice of appeal. And those are that the development authority did not follow the directions of council, I'm quoting, articulated in the direct control district for reasons which will be further articulated once we have a full record from the town of Canmore and a clean set of DP plans. The appellant deferred particularizing those pleadings. It has had the entire package available to it, what is before you, this DP application, and yet it didn't amend its pleadings. It is, I assume, relying on its written submissions as its pleadings and its arguments. But my argument to you is that is a breach of procedural fairness, of the tenets of natural justice, where you have to particularize your case, your grounds of appeal enough so that the other party knows what case it needs to meet, and also that you as a tribunal can manage the appeal, the procedures. The other pleading, which I'm saying is deficient, is in the last paragraph. It's not numbered in their notice of appeal, and it's a catch-all. I've used it before, I think. Developers, those that represent on appeal, we have the catch-all, such other grounds as may be presented within written submissions and at the hearing of the appeal. Well, that's what they're doing, but that doesn't save them. We need to know which directions of counsel are under appeal, which other grounds they intend to raise, so that we have an opportunity to properly and with enough time address them. It is a breach of procedural fairness, as I said, for an appellant to not adequately particularize their reasons for appeal in its notice of appeal. And it can't be saved through the written submissions, let alone at the hearing itself. The Municipal Government Act is clear on this point, and I'll refer you, I don't have it in the materials, but I'll quote it. At 686, which deals with development appeals, it says, 686 sub 1, a development appeal is commenced by filing a notice of appeal containing reasons with the board hearing the appeal. You did get a notice of appeal. Those last two items are boilerplate pleadings that contain no reasons. So they failed to test the requirement under the Municipal Government Act. So I'll now go through the appellant's other reasons for appeal, which are itemized as 1 through 4 in their notice of appeal, and make the arguments before you that those pleadings and the written submissions that they have in support raise no appealable issues. The first one, and I'll read it. It says, number 1, excuse me, the Development Authority has no jurisdiction to grant an amendment of a development permit which is under appeal, where Stone Creek was granted permission to appeal by Justice Wakeling in September 2024, and a final determination of the appeal of that development permit has not been made by the panel of 3 justices at the Court of Appeal. This is an incorrect statement of settled law. An appeal of an SDAB decision does not act as a stay, but it also does not foreclose the ability of the applicant, Base Camp, to apply for a new DP or unilaterally cancel its DP. And canceling its 2023 DP would have the same effect as what the condition is that the CPC imposed when approving the 2024 DP, was that when that 2024 DP is issued, the 2023 DP will be canceled. Now, Stone Creek's council is trying to portray this as some sort of subterfuge, that we are looking to avoid the appeal or the consequences of the appeal, which they rightly characterized as we're taking a risk by proceeding under the 2023 DP as we have with this Court of Appeal application already. Now, I don't doubt that the effect of the issuance of the 2024 DP, if that's the decision, would, and the condition being that the 2023 DP is canceled, and we've heard the reasons why the planning department wants that. It would otherwise have 2 DPs for more or less the same project. A bit confusing, to say the least. But that cancellation of the 2023 DP would, I grant them, undermine the appeal that's before the Court of Appeal. So be it. I don't want to tell them how to do their job, but I'll suggest that with respect to the issue of the pathway, that would be gone, but several of the issues that they raised at the Court of Appeal during the leave application that were accepted are still issues, could be issues under the 2024 DP if that's issued. So I would suggest that they wouldn't lose this appeal, really, but their, as we've heard, their biggest issue was the delegated power of the town to deal with the pathway and whether they could, in the worst case scenario from the appellant standpoint, take up a laneway for that purpose. That was one of the issues that was given leave to appeal that's before the Court of Appeal. And with the cancellation of the 2023 DP, that issue would no longer be before the court. However, I would suggest that an application could be made if they wish to carry on with their appeal at the Court of Appeal, that the same issues that are repeated in the terms and conditions of the 2024 DP could be carried forward, and that would form the basis of the appeal. So, this is not, we're not, they described this, the appellants described this as an abusive process. It's not. An applicant, a development permit holder, has every right to apply for another development permit. It can cancel its DP. We wouldn't, of course, because we're already acting under it at the moment at our risk. But that is within our control. And to the extent that has, from the appellant's perspective, an adverse effect on their appeal before the Court of Appeal, so be it. The second pleading that the appellants have in their notice of appeal, and I'll quote, "The Development Authority has no jurisdiction to cancel a prior development permit as part of the current application, yet purport to import conditions that from that prior permit into an amendment application that addresses only amended conditions." Again, an incorrect statement of fact and law. Development permits can be canceled. New development permits can be issued. The Development Authority has the authority to impose conditions it considers appropriate or necessary, and that appropriate or necessary comes from the land use bylaw at 1.10.0.2, which I'll read. "In making a decision on an application for a discretionary use," which this is, "or where a variance has been requested, the Development Authority may approve the application or approve the application subject to conditions considered appropriate or necessary." The Development Authority, ultimately the CPC, before we are before you, accepted the condition recommended by the Planning Department that the 2023 DP be canceled upon issuance of the 2024 DP. The Development Authority had that jurisdiction. The 24 DP is effectively a new DP. It is described as an amended DP, and as we've heard from the Planning Authority, the Development Authority, this is simply a shorthand, an indication as to what would be before the approving authority, CPC, that this is not a new application that required everyone to have collective amnesia and forget that this had already been recently circulated, and what needs to be addressed are the amendments to the 2023 DP, and to the extent any of those amendments required a further circulation as part of the initial process, that would have been done, but that wasn't required. But in any event, a full and complete development permit application, not just the amendments, the full application was before CPC. So the fact that CPC, as the approving authority, didn't dwell on matters that were unchanged from the prior DP, the 2023, that it had approved, it's not It's not a derogation of its duty as a development approving authority when deciding on a complete application before it to focus on items that were different from the last DP. That's what it chose to do. But the inference cannot and should not be drawn that this is somehow a derogation of their duty, that they didn't review and make a decision on the complete application. Their focus, I don't doubt, but I don't know, their focus was on the changes because nothing else was affected other than what those changes were. And those changes were highlighted. They didn't give the planning authority, the planning department, issues in deciphering them. They didn't give CPC issues in terms of deciphering them, but apparently they've given the appellant issues in terms of deciphering what those changes were, because they've asked for this process to be restarted effectively as if, as I said, the parties, including the town planning department and the CPC, assuming we've all suffered some mass amnesia and we can't remember what was already before them. So number 3, and there's 4 pleadings that I want to go through. So number 3, the third pleading, reads as follows. The number and scope of changes set out in the application requires a new development permit application, which needs to be properly advertised as a new application. We've heard, and we haven't heard evidence to the contrary, the DP application was properly advertised. We've heard that from the Development Authority. It was notice posted, and it also appeared in the online, and I think published in the local paper agenda for CPC. Now, the number of changes in and of themselves doesn't necessarily require a new development permit application, although technically the 2024 DP is a new DP. It, as I said, in terms of the planning department and the development authority's practice, if they're dealing with amendments, if they're, I assume, as it is the case with other development authorities and planning departments, if the amendments are of such a minor nature, they can probably be dealt with through the delegated authority of the planner. But if there's more of them, as there are in this case, they can be set out as an amended DP, but it still is a new DP. And as I said, and as we've heard from the Development Authority, the application before them, they deemed it complete, and it went to CPC as a complete application, and no objections were raised at that time. So the fourth pleading, similar. Stone Creek was provided no notice of the application by the Development Authority or the applicant. I don't think I need to rehash what I've said. There was formal required notice, and there was the informal between the parties notice. So now I've talked about already the 5th pleading and what I'll call the 6th pleading. It doesn't have a number, but it's the and such other grounds that we'll raise in our submissions and at the hearing. So the 5th pleading was that the Development Authority didn't follow the directions of council. We've now, through the written submissions, we now know what directions of council are being impugned, and I'll get to those in a moment because we can address those, and I'll address those in the alternative because my main argument still holds. They have to plead the particulars. The appellant can't rely on having sufficient time and being sophisticated in this process, rely on the written submission and the hearing process to describe their pleadings with enough particularity. So as I mentioned, I will, in the alternative, get to the arguments that the applicant has raised about screening, landscape screening along Silvertip Trail, and that the directions of council weren't followed. And I'll get to the issue of the visual impact assessment that they claim was another direction of council in the DC bylaw that wasn't followed. I'll get to those in particular. But I just want to summarize my arguments to date before I get into the alternative arguments. The appellant's notice of appeal, its pleadings, are woefully adequate, nor can they be saved by the plea of needing more time and more information. The appellant had sufficient time and a full record available to it, sufficient resources to hire legal counsel. It is itself a major developer in the town of Canmore, and it had the benefit, of course, of having gone through a thorough DP appeal process with the 2023 DP. Yet, it is somehow unable to draft sufficient grounds of appeal this time with this appeal. The appellant was also aware that most of the amendments between the first and the second DP are changes to the internal layout of the spa buildings and an internal pathway, none of which was the basis for its first appeal, nor apparently for this appeal as well. In fact, one of the main grounds of appeal of the first DP, the external pathway, and potentially that external pathway potentially occupying a lane of Silvertip Trail, that was removed from this 2024 DP. Yet the appellant nevertheless tries to argue that the condition replacing it, and there is a condition that deals with pathways, and it says that the applicant can pay cash in lieu, and we've heard that it has, and it's been received by the Development Authority. That this is somehow, that this payment of cash in lieu, which will be used at some point for the development, the building of this pathway, that this was somehow designed to bury the details of a pathway along Silvertip Trail in some development agreement that the appellant wouldn't have a chance to have any input over. Well, that's not the case. The appellant's complete satisfaction of this cash in lieu, of this pathway requirement, which comes from section 650 sub 1 of the Municipal Government Act, that can be satisfied as it has by payment of cash in lieu. So it's no longer, that condition has been satisfied. It'll be transferred over if the new DP is issued. That pathway requirement has been satisfied by the appellant, or sorry, the applicant, through the payment of cash in lieu. There's no obligation beyond that to design or come to some greater certainty regarding the alignment of the pathway and whether it will go into this lane of Silvertip Trail or otherwise. That is a process that the town has sufficient authority to proceed on its own, whether it does that through its powers under the Traffic Safety Act, if it's going to use one of the lanes, or it needs a road closure, a public hearing to do that. We don't know that the pathway is going to go into that lane because that condition that was in the 2023 DP that showed conceptually that this pathway would encroach into the lane, that's gone. As was mentioned, there is some discussions with the town and amongst the parties about a new alignment, but that process of determining where the pathway will go and how it will be funded is outside of this DP process, this DP that's before you. So, on that point, but related, the appellant did go so far as to suggest that because of the crowded utility corridors along Silvertip Trail and the risk of encroachment into the vehicle lane, that the applicant, my client, is somehow obliged to dedicate its own lands to accommodating this pathway between, to accommodate this pathway that the town, through a separate process, is designing. It's not, the alignment of the pathway is not a DP condition. The provisions that I think my friend on behalf of Stone Creek is arguing under section 650 sub 1, there are two conditions that a development authority can impose with respect to pathways. One of those is, and it's usually done with respect to greenfield subdivisions, building a pathway system within your community. And the second part of that is to build then a connection to the pathway system outside of your community. Those are the two powers that a development authority has with respect to pathways. There's no obligation in this development permit application for the applicant to build an internal pathway system. So the obligation then becomes a connection to the pathway system. That doesn't have to be on, and I don't think the development authority would have the right to require lands be dedicated for that purpose unless it had made that a condition of the DP, which it hasn't. Or, and in this case, we don't know what the alignment will be. I understand, because it has been discussed before you, that there is some lands available in the on my client's lands along Silvertip Trail outside of the fence that would be in a utility right of way that might be available for a pathway or the landscaping around it. But again, that requirement for a pathway is now outside of this DP. So it's not before you. If you determine that that condition was satisfied by the payment of the cash in lieu, then that's the end of that issue. So I'll now go into the alternative arguments, and again, I'll reiterate, my main argument, the pleadings were inadequate for the reasons I've set out. Their appeal should be struck. The alternative argument is if you don't accept that and you want us to address the arguments, and the two that I have left are dealing with the screening, landscape screening along Silvertip Trail, whether the development authority, CPC, followed the directions of council with respect to the visual impact assessment that's required. And the other one is with respect to, under the DC bylaw, the design requirements. And that one in particular, it's 14.11.5.1, which requires a pedestrian-oriented streetscape, I'm quoting, shall be established to allow for or encourage pedestrian traffic. The streetscape shall incorporate design elements such as wide sidewalks, separation of pedestrian use areas from vehicle use areas, outdoor furniture, patios, pedestrian scale, street lighting, bicycle parking, canopies, vestibules, formal trail connections, facade treatments that are sensitive to sidewalk location on a site-specific basis, and permeability of facades by the use of glass and doors, subject to Section 11 Community Architectural and Urban Design Standards. The appellants argued that the directions of council, as expressed in what I just read, were not followed because this requires a pathway to be built. It doesn't. The language is, a pedestrian-oriented streetscape shall be established to allow for or encourage pedestrian traffic. It's not the same as requiring a pathway to be built or cash in lieu for that purpose. Now, the cash in lieu for the purpose of that pathway along Silvertip Trail does, I argue, go in part at least to fulfilling this direction of council. It does allow for and encourage pedestrian traffic because the purpose of those monies is to fund, at least in part, that pathway. The other ways that the application, the applicant, and CPC as the development authority did follow the directions of council is that the facade treatments along that portion of the development along Silvertip Trail are sensitive to pedestrian traffic. Further, there was some confusion on this point, there was certainly a lot of argument by the appellants that they're concerned about the trees that have been removed and no obligation to put them back along Silvertip Trail. Well, that's just not true. There is a condition, and it's condition 21 and I think it's at page 111, I'm pretty sure it is. Yes, it is, of your agenda. That condition is, which is a condition of the 2024 DP, says that there is a requirement to screen with natural landscaping along Silvertip Trail. So that requirement is in the DP. It will be translated into the 2024 development agreement that follows that DP, and there is a obligation for that to happen, for the applicant to do that. And I don't think it should be properly before this board I'll call it evidence that sometimes these conditions just don't get fulfilled. Well, there is a process if it doesn't get fulfilled, and I think the appellant would have a right, because I assume it'll be following this, because this pathway and the screening of it is important to them and their development up the hill, that if that condition just doesn't get fulfilled, that base camp doesn't plant trees or do sufficient natural landscaping along there to the satisfaction of the development authority, the appellant would have rights to challenge that, because that is a decision that is appealable, or perhaps there's the opportunity to enforce through a judicial review process that the town, through its development authority, do what it's supposed to do, enforce that condition. So the screening issue, I know that the appellants want this done sooner than later, the alignment of the pathway and the screening, but that's just not the process, and that doesn't mean it won't happen, and that doesn't mean it won't happen to the satisfaction of those affected by it. Stone Creek, or my client, they do have an interest in it, but it'll be it's properly part of a DP condition. The screening, the tree screening, I assume might wait until the alignment of the pathway is settled, and so they know where to put the trees. So there's no point doing it now necessarily, but there will be the obligation through that condition, which will be repeated in the development agreement, to get it done. So the other argument that the appellants made with respect to this application and the determination through CPC that they didn't follow the directions of council was, as I said, with respect to what is referred to as a visual impact assessment. And that's found on 14.11.6.4 of the DC bylaw. They specifically argue in their written submissions sub-E, because the A through E provisions, and I'll just read the first part of it, it says say in that DC bylaw that every application must submit to the satisfaction of the approving authority a visual impact assessment which includes an A through D, are mostly related to the what can be seen from the Trans-Canada Highway or Palliser Trail is the other one, and benchlands trail to the extent they're applicable, what can be viewed of that development from the highway or those roads traveling in either direction. That part wasn't appealed, but there is photographic evidence that was provided by the applicant in its 2023 DP, which was transferred over because nothing was affected by it, to the 2024 DP application to show the views from the Trans-Canada Highway of the development. The one that the appellants are taking issue with is mitigation measures, and this is sub E. Mitigation measures proposed to minimize the negative impacts of parking and massing through the application of natural landscaping, building articulation, and roof treatment. We've seen the renderings, the facade of the proposed development along Silvertip Trail, and the care that was put into the different types of fencing, the different types of materials, and the articulation of those buildings, the 3 buildings that are along Silvertip Trail. And so that, to the satisfaction of the Development Authority, satisfied their visual impact assessment, or was treated as the visual impact assessment, because it's not built yet, so all you can deal with are renderings. The other part is with respect to the landscaping, that is condition 21 of the 2024 DP. The visual impact assessment of that natural landscaping along Silvertip Trail will have to be assessed at the time those trees are planted. I mean, it could go by a rendering, it can do it off those renderings when that landscaping plan has been submitted and approved, but that will satisfy that direction of council, that the applicants and the Development Authority follow the directions of council in terms of reviewing and being satisfied with a visual impact assessment. So I'm almost done, but I do want to, I was taking notes, of course, as my colleagues for the appellant were presenting, and I just want to go through some of these that caught my attention, and I may have dealt with them already, and to the extent I can, I'll try to edit that out and not bring it up again, but they talked about, and this was Ms. Stokes' presentation, the amended DP being an abusive process, because they argue that it was a less than fulsome application that was before the planning department and then before CPC as the Development Authority. We have no evidence that it wasn't a complete application. They also stated that the amended DP application is misleading. I don't know how. The amendments were clearly documented. All the plans that were required for a complete application and all the studies and other documents that were required for a complete application were brought over from the 2023 DP to the extent that they weren't amended and weren't affected. And those changes to the 2023 DP approval were highlighted. As I said, the Planning Authority didn't have problem reading the plans to see what the amendments were. CPC didn't, but the appellant somehow suggested this application was misleading. They did spend much time rehashing arguments about the 2023 DP. That's not before us. You heard those arguments. You approved it with conditions. So the arguments that were made with respect to a development agreement being signed and registered on title, as they do register them on title because they do follow the lands. That, as I think we heard from the Development Authority, if the 2024 DP is issued The 2023 DP is canceled, and so would the development agreement be canceled. So arguments about missing deadlines of the town to do some sort of conceptual drawing of the alignment of the pathway, it's not before you. Okay. CPC, this is now, I'll say a paraphrase from Ms. Anderson's presentation. CPC only had before it the amendments. It didn't. It had a complete application with full drawings. The 2024 DP, this is another paraphrase, relies on the continued existence of the 2023 DP. That's false. It doesn't. It borrows from what was submitted under the 2023 DP if there were no changes. It amends those plans that show the changes, but it doesn't rely on the continued existence of the 2023 DP. It has its own complete set of plans. No allocation has been made for screening trees along Silvertip Trail. I addressed that condition 21 of the DP that's before you. The pathway should be accommodated entirely within the site. I addressed that. That's not a requirement. The Development Authority did not impose a condition through Section 650 that the development have a thoroughgoing internal pathway system. This isn't a larger subdivision that would have bike paths throughout it. The other ones that I have here, I've already mentioned, so I will conclude it there and happy to take any questions.
Thank you for your submission. Any questions from the board members at this time? Thank you. At this time, we'll invite anyone from the audience who wishes to speak in support of the appeal. Please approach the podium and give your full name. If there's anyone in the audience who wishes to speak against the appeal, please approach the podium and provide your full name. If there's anyone in the audience who wishes to speak in a neutral position, either for or against the appeal, please approach the podium. For the clerk, do we have any written submissions that have been received in addition to what's contained in the package?
Sorry, Mr. Chairman, for interrupting. Our client would like to speak, so we were going to put him up with the closing, but he can as well come and speak right now to some of the comments made. So I leave it to the board to let us know where you'd prefer he fit.
Okay, once we get through the submissions, we'll invite him up at that time. Thanks.
No additional written submissions at this time.
Okay, thank you. Okay, we have a request from the appellant. May I speak to that? Certainly.
I think this is a request for Mr. Turcotte to speak. This is, I'll call it out of order, but I don't mean it in the sense that it's, out of order. It's out of the process. The appellant had their opportunity during their presentations in the main to make their arguments. If they want to include Mr. Turcotte in their closing remarks, which are for the purpose of summarizing, addressing what was said by the Development Authority or us, for example, that they couldn't have anticipated during their presentation in the main, that's fine. But if they're going to use Mr. Turcotte's presentation for other than those purposes, then I would object.
Thank you. Please, if you'd like to respond to that.
Sure, what's been proposed is fine. We can have them as part of closing. I just wanted to make sure we we
get on
didn't,
record that he wanted to.
weren't out of order with what you were describing should occur.
Okay, thank you. Thank you both. We'll hear from Mr. Turcotte at the closing. Okay, at this time, the board will take a brief recess of 15 minutes and return at 2:15 to continue. Thank you, everyone. I'll call the hearing back to order at this time. At this time, we're going to be moving forward to the questions for clarification to the board. Does anyone on the board have any questions for clarification for administration? A couple of quick questions for admin. Just wanted, could you, for clarification purposes, can you confirm that the guidelines were followed in regard to the advertising, posting on the agenda and to the public for the CPC portion?
Yes, all of our guidelines for posting and notification were followed.
Okay. And also for clarification, can you confirm that the transaction regarding the cash in lieu has been completed and that those funds have been received by the town of Canmore?
Those funds have been received for the previous DP application under the previous development agreement. And for this amended DP application, we would have those provided by the applicant again.
Okay, thank you. Any further questions for admin? Do any of the members of the board have clarification questions for the applicant? Any members of the board have clarification questions for the appellant? Does the board have any questions for any other person? Does anyone who presented here today have any clarification questions for the presenter? If yes, please direct your questions through the chair. Does administration or the development officer have any closing comments?
No further comments.
Thank you. Does the applicant have any closing comments? For a closing, yeah. Oh, sorry, you're correct. At the beginning, we flipped that order at the beginning.
At the end, because the appeal is the appellant.
Okay.
They go last.
Yeah, I've just been informed that that is the proper process, so if the applicant has any.
You've just heard from me for an hour or so, so I have nothing further to add or close, but I would ask that I be given the opportunity, if needed, to rebut anything that's said during closing arguments from the appellant that I couldn't have anticipated that they didn't already make in their main submissions.
Yes, you'll be given that opportunity if needed.
Thank you.
Does anyone else who made a presentation, other than the appellant or the applicant, have any closing comments? And if the appellant has any closing comments, I'd invite you to do that at this time.
Good afternoon. My name's Guy Turcotte. I'm with Stone Creek Resorts and part of the Silvertip development. And thanks for your time. First thing that I would like to say is we did try to convince Base Camp to give us a couple weeks to postpone this, because I really believe we're close on agreeing on a path design, past this development, but that was not accepted. But we wouldn't have. So if they haven't liked hearing our arguments, we sure did try to postpone it, because we really believe that we're close. The second thing that I want to say is, how did we get here, and how did we sort of end up in this mess? Well, on February 7th of 2023, February 2nd, we received an email from a transportation engineer in the town here, and engineering manager, and Ryan is copied. Subject: Silvertip Trail multi-use pathway. Just saying that there's some opening introductions here, but the town has been undertaking some concept planning for a new pathway that will be retrofitted on the existing carriageway just north of the Holiday Inn site, continuing the single inbound lane
from Palliser Trail 300 meters east of the existing crosswalk. The draft concept is attached below for your information. Based on prior work undertaken, to inform you to retrofitting of the pathway infrastructure along Palliser Trail with a single inbound lane onto Silvertip Trails anticipate to function with adequate capacity as the area develops further. And we responded, thank you for your email and information about the potential multi-use pathway. Would it be possible for the town to provide a detailed plan with the legend so we can clearly see the proposed design? Is there any additional detail of the transition of the pathway going up the hill? Because this was only about 400 meters. And we state the current roadway has been designed based upon our recommendations outlined in the approved traffic impact assessment, factoring in full build out of Silvertip Resort and all future traffic that will be generated. So we would appreciate the opportunity to meet with the town to discuss the questions above. We look forward to discussing with you in more detail. So we never heard a word from the town after we received this email. So they were going to close down one lane, the right-hand lane going up Silvertip Trail was the plan. And then when we saw that Base Camp's Nordic Spa DP had been approved, we had never received any information of this DP. Maybe we should have picked it up in the advertising. We didn't. We only saw it advertised, after the fact. And we got the plans, and we saw that the one lane of Silvertip Trail was being closed. And that really concerned us, and then we started studying the plan in more detail. And then we became concerned in other areas like, screening and so on and so forth. And so our study of the DP, was more intense after that. But we did not receive any information until that was posted in the newspaper. So after we appealed the DP, which you approved, and with conditions, and then we moved through the court process to see if we could get leave, and then this summer we had discussions with the Base Camp people. One of their investors got us together in, let me see if I can find the email. So this was in I think it was late June and July. I think we had 3 meetings. Bill was there, I believe Sky was there, Karen Finley and myself. And we thought we were coming upon a plan for the pathway and the screening between us. And the, let me see here if I can find the right email I'm looking for. So one of Base Camp's investors got us together, and we had the 2 or 3 meetings. And like I say, I thought plans were going fine. We did get the plan that Mr. Fasecki put up on the screen this morning. And could we get that back on the screen? Is it possible to?
Certainly can.
Okay, let me see if I can. Yeah, okay, that looks like the one. Okay, it's not up on the screen. Okay, so the plan here that says August the 6th, so we did see this plan, And, you know, I had, so I received this from Mr. Anyways, the individual who got us together. And I provided my comments back. He said, I met with Bureau and Sky, and he said, we've agreed on this. So I thought, you know, this is moving forward. And he said in his email to me, when I get the detailed plans, and I think we were talking about landscaping plans, he said, I'd like to get back together with you first part of August. And you know what? We never heard back after that. That was it. That was the last conversation that we had about what we had agreed to. And then this individual who lives in Canmore was going away for 6 weeks or so I didn't get back together with him till he got back. And at that stage, we were, I think September the 28th is when we were before the Court of Appeal to get leave anyways, we never heard anything after that until I met Viral in December at the Boda lunch up at Silvertip. And you know, Miss Anderson noticed in the paper the advertisement of a new DP being approved, but we never received any information about the amendment, zero. And I've checked Karen's email, but there was no documents. We didn't even know there was an amendment going on, honestly. The first time we saw it was in December, about December the 6th. And so when I spoke to Mr. Fizeki at the Boda lunch, and I said, geez, we just saw your, you know, you got a new DP approved. And he said, I hope you don't appeal. And that started I'm going to say, a dialogue between us and between Andy, or Birol and myself, and Andy, you know, with the town engineering manager to see if we could get this pathway approved. Because when we saw the amendment and we saw that there was no pathway in the DP, you know, we started to get very concerned because, you know, a DP is supposed to have, as part of the DC bylaw, you know, a pedestrian-friendly design, you know, in with the plans. So it does say that. Anyways, so the email that Mr. Fizeki put up this morning that we got, I don't know if it was December 16th, I think? 18th. And on that email was the first time that we've seen from the town that they were prepared to say they were going to let us keep 2 lanes going up Silvertip Trail. So I sent a response saying, thank you, Andy, and then, you know, I think it was a few days later, he provided a profile of what 2 lanes of traffic would look like. Everything looks, you know, like something we could accept. And we've been working the last month, I would say, to try and come up with the details on that. And that's why we wanted to postpone this, because I think we're really close on moving forward with the plan that, you know, how the multi-use pathway would be, you know, would be going past the base camp property. And we met as late as last Thursday. And I think we're real close to getting this agreed between us, and I hope that we can get this thing agreed and all get on with our lives, because that's not, you know, we really don't get a lot of joy out of this. But, you know, our TIAs, our traffic impact assessment, says we need 2 lanes going up that hill up Silvertip. You know, it's a, you know, 8-10% grade hill, and, you know, you've got slower construction traffic. It's got to be in the right-hand lane. And the road has been there for 25 years or longer, and it works really well because we've got 2 lanes going up the hill. I mean, bikers can go up there, and you know, you can get around them, and I think it works really well. Anyways, we are 100% supporters of the multi-use pathways in this town. I just don't believe we need to be closing vehicle lanes to put them in place. I've offered the town as much land as they need to the right of the, of the Silvertip Trail. And we totally support bikes. We're not against bikes. And we really all want to make this work. So one thing that I have never said to Beerald is to get the pathway off of his drawings, because I've never thought that thought in my mind. We've wanted to know where the pathway is, where the screening is, and like I say, this drawing, there's none of this landscaping and trees screening in the pathway that didn't make it to their amended permit. So what we thought we had agreed on didn't show up in their permit, and this assumes taking a couple of meters off Silvertip Trail, putting in a new curb, so they have enough land to put in the multi-use pathway, the trees. So I think it works, and we're getting really close. So anyways, we're not here to really be against anybody. We support bikeways, but we don't want that lane going up Silvertip Trail. I don't think there's one resident up there that wants that right-hand lane closed. Anyways, I think hopefully we're getting there with the town, and I think so. There's been sort of three in this at this party, and until we get that pathway and know where it's going, it's been difficult, I think, for Base Camp and ourselves. It's not. There's three of us involved here. So, anyways, I think that's pretty much, the points that I want to make. Oh yes. I think I've made all the points. Thank you.
Thank you, Mr. Any questions for? Okay, thank you. Anything to add to that? Okay. The mic is still on.
Sorry if there was any confusion. That was Guy and myself tag teaming for the closing. Thanks for allowing that opportunity for Mr. Turcotte to speak. I just have a few closing comments with respect to our presentations today. Number one, I'd like to clear for the record, I'm not an architect. I should say I went to school, University for Architecture and Urban Planning, but I don't want it to be misunderstood that I'm actually registered to do anything other than practice law and be a mom. And I didn't register for that. A couple points. I do note that the applicant keeps referring to these municipal improvements as off-sites, and I would like to emphasize to the board they're only off-site because they didn't include them on-site. So they're could be all on-site, they could be partially on-site, but they're only off-sites, and therefore kind of take them off the plans because of the pushing of them out that to the property line and beyond. So we'd like to make that clarification that they didn't need to be off-sites. They could have been on-sites. Number two, confidential discussions. So one of the slides that went up on the screen before regarding the 2 lanes, there was confidential discussions actually since the appeal was filed. And they were supposed to be, towards settlement, et cetera. We haven't given you all the detail as to those confidential discussions, whether they're with Base Camp or with the town. So we just want to plant the seed that you're getting part of the picture, but the other part of the picture is really not available for us to talk in a public setting. And, I have copies of, plans from the town trying to move this along, but we're not at liberty to really throw them out there into the public forum. So I will say that one email is one email of several that we've been exchanging and kept mostly confidential, the rest of the content. With respect to the notice of appeal, we respectfully obviously disagree that a notice of appeal you can challenge conditions, you can challenge the jurisdiction of the board, you can challenge that the advertising wasn't appropriate, you can challenge and say planning reasons in your notice of appeal. Unlike a statement of claim, which is a very more rigid process, This is more fluid, and as long as you have the bare, statements within there to challenge, again, not just planning reasons, you can have other challenges. They're typically sufficient for a notice of appeal, and we've been doing this a long time for a lot of clients, so there's no perfect way to do it, but you do have to, there is enough within our notice of appeal to stand on its own. Other item is with respect to the development agreement. One of our concerns, of course, is if we're canceling the old one, what does the new one look like? And so our concern is the same, setting money aside without a design. First of all, how do you get the amount of money to set aside if you don't have some sort of design? That's always kind of baffled me. How do you come up with the $400,000? It should be based on some assessment of some design cost and that type of thing. So it's almost like the cart before the horse. We're just saying design, let's get that done, let's get it in a document, and let's have it properly documented so we're not back here again, going full circle again. And then the other item is, and I believe Mr. Turcott touched upon it, is this really is a relationship of three parties. Sometimes we're told by the town, go speak to base camp, and then the base camp will say to us, well, that's actually a town issue. And so we keep kind of going in circles. So I think we're at a point, I feel very comfortable that we're at a point where we can get some success here and perhaps alleviate uncertainty and get where everybody needs to be. So we don't have to keep either appealing these through the SDAB, appealing them through the Court of Appeal again, and then all coming back full circle to the same question, which is, can you please design, put in a document, and let's move on. So with that in mind, we had originally discussed options for, what we were looking for in concluding this process. Having been through the process now, and having, I think, both parties able to express where they were at, I have one suggestion for the board for your consideration, which is this, is normally when you close proceedings, you have 15 days to write your decision. And I've done this before in other appeals where we ask the board to postpone the closing of the hearing to see if we can come to some agreement and then hand in what we come up with to you. And then, as opposed to it being a fulsome written decision of all matters, it would be, we will accept these conditions, or we will accept this plan, or we will accept this wording in the development agreement, or something like that. I just think we're ripe for getting a solution, and I'm a little hesitant, like the last SDAB decision, is that we get conditions that we then have to appeal again because they're not sufficient. I think we have three able parties, the town, base camp, and our client, who know where we need to go and can help paper that. And then that would relieve the board from having to, if you will, impose something that we again find insufficient. That's what I'm trying to avoid. and so I'm just looking at, it wouldn't be a lot of time. If we can come to some resolution, we'll know. But we are so much closer than we were even 3 weeks ago that I'd hate to see the board come out with a decision than us stopping our settlement discussions. It seems to me to be a reasonable option to give a bit more room before you have the 15 days triggered to write your decision. And again, I've used that in other board processes, so I just simply offer it as a means to potentially, I'm trying to close this and in some final way and relieve uncertainty. And it just came to my mind that that might be one option to consider. Thank you.
Okay. Thank you for your closing comments. Would the applicant like to respond to the closing comments? Thank you.
Hey, Mr. Chair, members of the board, Bob Homersham again. Sounds like we're all getting along. It's great. I don't, the parties are cooperating with the town to see if an alignment through and a detailed cross-section of the road and where the pathway and the landscaping would go along Silvertip Trail along this development, but it has nothing to do with this DP application. That is outside of this, and we are willing and able and happy to continue those negotiations to a conclusion or otherwise, but we don't want this process, this DP appeal process, to be used as leverage against us, and that's what we feel is happening. I've argued that this appeal is frivolous and vexatious, and it's being used to leverage a finalized plan for this pathway that isn't part of this DP, and there's nothing compelling the applicant, the approving authority, to include a completed designed pathway as part of this DP. We've satisfied our requirement with respect to section 650 sub 1 of the MGA by paying the cash in lieu. The design process will go on. We're happy to participate, but we do not want to be held hostage. We're not interested in any further adjournment or delay or adjournment of closing the public hearing, for example. Thank you.
Okay. Thank you. Do the people who have represented today feel that you've received a fair hearing? Thank you. Okay, the hearing is now concluded. As a reminder, the board will meet in a closed session to review the evidence presented, and as per legislation, will provide a written decision with 15 days of this hearing. No decision is binding on the board until it issues a written decision. The clerk will provide notice of a decision to the appellant and the applicant and post to the town's website. And we are adjourned. Thank you.